joint committee meeting on civil law, health and human services policy, and health and human services finance, among others, will come to order. Members, we're not going to mark folks down for this. We do not have possession of House File 2167. This is an informational discussion based upon a series of events that occurred over the past primarily 3 weeks. Just by way of my background before Mr. Gehring speaks about this bill, as well as Lori Beyer-Kopinski. In November of last year, I had heard a discussion, I think it was on NPR, but it was on the radio, whereby the Supreme Court came down with a decision that essentially masked information in a contract which would have been violative of the open government policies under Chapter 13. So I asked that a bill be drafted in order to correct the discrepancy as highlighted by the Minnesota Supreme Court. We introduced that bill. It was heard by multiple committees, both in the House and in the Senate, in order to address the Chapter 13 discrepancy, ensuring that information contained in government contracts is open to the public for examination. This is, of course, not a new principle, members. I recall, I think I was in second grade when the Packwood Commission lamented about $400 hammers and $635 toilet seats. That, of course, was with military, primarily military contracts and Pentagon operations, but the principle operates the same at the state level. So with that in mind, we sought to correct this discrepancy. In the recent, towards the end of session, health plans have come forward stating that this was going to cause some problems for them. I am still not clear as to what the health plans were doing from 1999 when the law was enacted until November 20th when the court decision was rendered by the Minnesota Supreme Court. But that is the subject of this hearing, as well as how we can effectively reach comity if that is in fact possible. But with that in mind, I would ask Matt Gehring of House Research to give background of the current statute, the Minnesota Supreme Court decision, and a summary of what House File 2167 is intended to clarify.
Mr. Chair, members, so all the things that Chair Lesch just described are contained in a summary document that should be in your committee packet titled Government Contractors and the Data Practices Act. It looks like this. And I'm going to walk through in a minute what exactly the law is as it relates to contractors with a government entity, although I thought maybe I'd first start with just a 30-second overview of the Data Practices Act in general, because I know a lot of members of this committee don't normally serve on civil law. So the Minnesota Government Data Practices Act is the state's equivalent of the federal Freedom of Information Act. This is the act that requires public disclosure of all data held by government entities. The Data Practices Act is in Chapter 13 of statute and applies to a set of defined government entities in the state, which includes most state agencies and departments in the executive branch, and then also political subdivisions, so school districts and cities, some towns but not all towns, and counties as well. The judicial branch has its own set of rules and related to access to judicial branch records, and the legislature also operates outside of Chapter 13. The presumption of the Data Practices Act is that any piece of data that's in the hands of a government entity is public unless the legislature has specifically authorized it to be classified as something other than public. Those classifications include a classification of private data, which is data on individual people, and a classification of data as non-public data, which is data not on an individual person but on an entity. There are also more strict classifications of confidential data and protected non-public data, and these are classifications that are typically used for law enforcement types of purposes. Typically, when we're talking about the Data Practices Act, we are specifically talking about a government entity's operation and handling of data, but there are circumstances in the Act that extend the requirements of Chapter 13 to private entities, and those are circumstances when a private entity is engaged in a contract with a government entity to perform some function. So in the document that you have in your packet, I sort of lay out what the principles of Chapter 13 are as they relate to government contractors. So there are two primary subdivisions that regulate the activities of private government contractors within the Data Practices Act. First is Section 13.05, Subdivision 6. This is a subdivision that was actually first enacted in 1979 and has been in place since then, that regulates circumstances where a government entity is providing access to its own data to a private contractor for purposes of performing a contract. So this provision requires that if you are a private contractor receiving data from a government entity, you have to comply with the Data Practices Act as if you were a government entity. The second provision in Chapter 13 that deals with private contractors is Section 13.05, Subdivision 11. And you can see this in the middle of your handout in the packet. This is the provision that regulates circumstances where a private contractor is performing a government function according to the terms of a contract with a government entity. So if a school district or a unit of government of some kind enters a contract with a private contractor to perform some sort of function of the government entity, then this provision says that the contract is required to include terms in the contract that specify that the contractor must comply with the Data Practices Act and comply as if it were a government entity. For the most part, these provisions have been, I don't know if it's fair to say they're quite backwater provisions, but there were lower profile provisions of the Data Practices Act until around 2010, when a specific case arose up north that had to do with a newspaper's requested access to some subcontracts that had been issued by a school district. So on the second page of the handout, I've laid out kind of the basic facts and legal background of the case called Helmberger versus Johnson Controls. This is the case that also is commonly referred to as the Timber-J case. So this is a case where in the St. Louis County School District issued a contract for the construction of some new school facilities. The contract was entered with Johnson Controls as the general contractor, and apparently the terms of the contract that were entered did not include the required data practices terms that are required by 13.05 Subdivision 11. A representative of one of the newspapers in the area had requested a copy of a subcontract that had been entered for architectural services related to these school construction projects, and the newspaper was refused access to those copies. This initiated a series of legal actions in an attempt by the newspaper to get access to the contract. It started with a request to the Commissioner of Administration for an advisory opinion to opine as to whether the terms of the contract required the subcontractor to disclose the terms of their subcontract with Johnson Controls. At the time, the Commissioner of Administration opined that because there was a government function being performed, and the government function was the construction of a school facility, that the subcontractor was required to disclose the terms of the subcontract. Despite the advisory opinion, the subcontractor still refused to turn over the copies of the contract, and the decision was appealed to an administrative law judge. The administrative law judge heard the case, had a factual hearing, and issued a ruling that went contrary to what the advisory opinion of the Commissioner of Administration was, and determined that the architectural services that were at issue in the subcontract were not actually a government function, and therefore the subcontractor was not required under 13.05 sub 11 to disclose the terms of the contract. The decision of the administrative law judge, because it went against the newspaper, was appealed by the newspaper to the Minnesota Court of Appeals. The Minnesota Court of Appeals took the case and reversed that decision, so it went back to something similar to what the Commissioner of Administration had opined on, and found that the construction of the school facilities was a government function, and that therefore the contractor was subject to data practices and required disclosure of the terms of the subcontract. This decision was then appealed to the Minnesota Supreme Court, which issued its ruling just last year in 2013. The cases or the sort of litigation history in this case mostly revolved around an analysis of what constitutes a government function for purposes of data practices, and those lower court and the commissioner's opinion sort of presumed that the Data Practices Act was going to apply even if the terms weren't in the contract. But the Minnesota Supreme Court took a different position on this and actually didn't engage in analysis over what constitutes a government function, but instead sort of hooked onto the fact that the terms of the contract didn't give notice to the contractor that data practices was going to apply, and therefore, because those terms were not included in the contract, Johnson Controls, as the general contractor, was not required to comply with the Data Practices Act. And as I said, because the Supreme Court determined that the failure to include the terms in the contract were sufficient to exclude the contractor from being required to disclose documents under the Data Practices Act, they didn't reach a decision about whether there was a government function being performed or not. So that's kind of, Mr. Chair, the basic background on the case and where the status of the law is. So there's sort of two legal issues that came up in the case, and on the third page of the document you can see I sort of laid out what the questions are and what the answers were. First is that under the Johnson Controls case analysis, the state of Chapter 13 is that the Government Data Practices Act will apply to a government contractor only if the terms of the contract include a specification that the Data Practices Act will apply. So if the government entity doesn't include those terms under the court's analysis, then the contractor is not subject to Chapter 13. And I think there's been some discussion about whether that was the original legislative intent of that subdivision or not, but that was the majority opinion of the court.
Thank you for that testimony, Mr. Gehring. Next, Lawyer Bayer Krupinski, by the Information Policy and Analysis Division, will provide some testimony. But prior to that, members, for those of you whose eyeballs are rolling to the back of your head on this, you would note that there are some data practices disciples in the legislature, and the understanding is that data held by government, information held by government, is presumptively public information. So, and some of you may not be aware of that, but it's so that government can't hide information. And if you're going to get an exception to that, whether it be through a contract or anything, you have to come to the legislature here and request an exemption and explain your reasons for that too. So therefore, we're accountable if there's stuff going on with taxpayers' money that we've kept secret, both from ourselves and from the public, because it becomes a big issue. So I just wanted to lay that meta fact out there because it may have been overlooked as we start to get down into the weeds on this. Ms. Bayer Krupinski.
Mr. Chair and members, I'm Lori Bayer Krupinski. I'm Director of Community Services for the Department of Administration. I oversee the Information Policy Analysis Division as well as 5 other programs and admin. IPAD is the statewide resource for citizens, state and local government, the media, and the legislature on both the Data Practices Act as well as the Open Meeting Law. During session, you'll see us providing technical assistance so that any data practice language that passes is as clear as it can be without having an unintended consequence. We know that not a lot there, I'm not sure what the chair called them, aficionados. Not everyone is an aficionado, but you sometimes have bills that have data practices implications, so we want to be able to help folks with those. We leave the advocacy and the tough policy decisions to you and other folks. IPAD, as Mr. Gehring also mentioned, staffs the Commissioner of Administration's advisory authority around issuing non-binding advisory opinions. And since my staff and I help explain these laws to normal people every day and have researched and written many of the advisory opinions in this topic, we were asked to provide you at least some background, some overview. It's not all as hard as you've been led to believe. As Mr. Gehring mentioned, Chapter 13 is going to apply to certain government entities, not all of them. So the legislature and the courts, they are subject to their own laws. And it also includes a number of defined terms. Government data is a defined term. It is all data collected, created, maintained, disseminated by a government entity, which you know is state and local government, state agencies, watershed districts, and the like. So in 1999, in response to some recommendations from a commission to study data practices that the legislature formed, 1305 sub 11 was enacted. And it was really due to the concerns that in 1999, government was more often starting to outsource some of the work that they had been doing in the past, and that there was concerns about, you know, can I follow the money? Will I be able to know what government's doing with my resources? And will all the protections and all the rights that I have under data practices apply when I hire somebody? So this provision was put into place. Current law requires that a notice be included in the contracts. State agency contracts include the full notice, as do grant contracts, about data practices applying. Because the Court of Appeals case law and because the advisory opinions going back these last 15 years said, even if it's not in your contract, it doesn't matter. The terms are going to be inferred. You will probably see 100 different varieties of flavors of what kind of data practices language was in a city or a county or a state agency contract, whether or not it was the whole notice or whether or not it focused on areas the government cared about, like make sure you don't lose my students' data and leave it in a ditch floating around in Wisconsin, things like that. So what people cared about. So we were all going along fine, and then in 2013 we had this case that said, pull out your contract because that's what's going to apply. And so many government was doing that for the first time, and many citizens were asking for copies of contracts so they could see how well their government was doing about putting these terms in the contracts. What this bill is intended to do is bring the law back to where we thought it was. This has been a legal requirement. Some folks might say there used to be discretion, that the Supreme Court case creates some discretion around this. I wouldn't characterize it as discretion. It's still a legal requirement. So yes, can government decide to violate the law and not include it in their contract? I suppose. You have also enacted civil and criminal penalties when government willfully violates the Data Practices Act. So given that bureaucrats are by nature conservative, I find it highly likely that a government would purposely not include these provisions, but certainly they could be forgotten by accident. What I also wanted to say, I wish that I could say that this bill changes the classification of things. It doesn't. The answer is always going to be, it depends. This bill doesn't make all subcontracts public data. Some subcontracts might be government data, some might not. An example I can think, if I have if my admin has a subscription to Newsweek, you're going to get to know how much I pay for my subscription. You're probably not going to get to know how much Newsweek paid Boise Cascade for the paper. But there's all different kinds of ways that government can be contracting and how the prices are figured out that could be government data. So I contract with someone who then runs a call center around a student survey. That's going to be, we want to be able to make sure that the data is protected and there's going to be access going down the line and you can follow the money. There's just not a one-size-fits-all answer. What this bill has raised is citizen awareness as well as vendor awareness around, what the heck covers my data? Is there a data classification I've got for the kind of data that I'm creating with the government, and how far is that reach into my private organization? I've certainly, in one of my other programs is the STAR program, which is assistive technology for folks with disabilities. We have a contract partner, and we've had them for a really long time. We made a request for some data from them, and they said, well, you can't have that. That's our data. And I'm like, okay, read your contract. It's just funny. I don't often have people telling me that I don't know what the Data Practices Act says. And they're like, no, you're wrong about what the law says. And I'm like, no, it's in your contract. That's our data. You're doing work with government money. It's our stuff. So many people didn't really fully understand what their contracts meant, or that if something was missing in their contract, that the law was still going to apply to the data they were creating for government. So this bill really doesn't change classification, and everyone is looking to, is there something more data classification that contractors need in any certain field or what have you. So that is what is before you really. The bill is to bring the law back to what we thought it was. Doesn't matter how you write your contracts, this law is going to apply. will people probably get more requests than they got in the past? And then, yes, that's probably true. And when government gets a request, and it will have to come to government first, because the contractor is not responsible for public data if the government already has it. So you have to start with the government and say, hey, do you have this data? And if they do, then they're going to provide it to the requester. If the government doesn't have it, that would be the point where they would look to their contractor and say, hey, someone's asked for this. Do you have it? Does this exist? And then you do the same analysis you do whenever you have a data request. What classifies the data? Is there any student data? Is there any trade secret data? You know, what do I have to do to meet that trade secret test? Are there other statutes? Are there federal laws that protect anything? And you go through that. That's what is going to happen in these instances as well.
Thank you, Ms. Byer-Kopinski. Mr. Neumeister, you're on deck, wherever you are. But there may be questions, Ms. Byer-Kopinski. You have questions? First question I know that I do have, and Ms. Representative Hortman has a question. Due to the apparent practice of deciding that maybe the law is not going to be followed since 1999, paired with the fact that there are civil penalties for failure to adhere to that law, how much legal liability, how much exposure does the state of Minnesota currently have based upon agencies' decision not to follow the law? Can you say that? And I guess the only way you would know that answer is if you knew how many and what kinds of contracts were not followed. So if we have to wait till we hear from representatives of the department, that's fine. But if you have that information, I'd like it from you.
Mr. Chair and members, thank you. There are contracts that the Department of Administration has the authority to approve, and then there are lots of other contracts as well. I don't have any solid numbers for you for how many contracts may not have a full notice or something less than a full notice, because before November it didn't matter. Certainly the contracting practices at the Department of Administration for any new contracts coming in since November, that section is being flagged, and if contracts don't include a full notice, they're getting sent back to make sure that they do. So that's the information I do know. There are tens of thousands of contracts that state agencies enter into every year. I can't even estimate the number at the local level and how many that might be.
Is there, Ms. Byer-Kopinski, what's the statute of limitations under Chapter 13 for someone's ability to sue the government for our failure to adhere to our own law? Do you know that? Is it 6 years, standard statute of limitations?
I think, Mr. Chair, I think so.
Okay.
I don't have that answer.
Okay, well, maybe the department can help us out with our exposure on that. Do you know, Mr. Gare? 6 years, okay. Thank you. You have some other questions, Ms. Byer-Kopinski. Representative Portman.
Thank you, Mr. Chair. My question is both for Ms. Byer-Kopinski and for Mr. Gehring. Subdivision 11 applies to, the header says privatization, and it applies to contracts where the government contracts with a private person to perform any of its functions. So this subdivision is limited to those contracts where the government is privatizing any of its functions. And the Gehring memo touches on this briefly, that it wasn't an issue at the Supreme Court. But can you fill us in on what kind of contracts fall into this privatization category versus contracts the government has with entities that don't fall into it?
Ms. Byer-Kopinski.
Mr. Chair, Representative Portman, that is, as Mr. Gehring mentioned, is kind of an open question. In the WDSI case, the Court of Appeals created this government function test where you're absolutely right. The statute says any of its functions, and the header is, kind of in statutory interpretation, the header is not supposed to mean anything. So there is, that is an open question. Certainly the advice that my office has been giving, and especially that I've been giving for the last decade, is any of its function is when government pays for something, to the extent government's paying for it, that it is subject to data practices. You can follow the money, be it a grant, be it a contract, be whatever it is. But we are certainly hearing more folks who believe that building a school or building a jail with statutory authority isn't a government function, or busing school kids. I mean, we're hearing lots of that, and that's something I think a court will have to answer, or the legislature will have to decide. Do you mean a smaller subset of contracts? Because we are certainly advising people that it means you can follow all government money.
So,
I don't know if Mr. Gehring has anything to add. On the basis of the research he did below where the case was at the Supreme Court.
Mr. Chair, Representative Portman, yeah, I mostly agree with what Ms. Byer-Kopensky said. But the analysis in the cases is a little bit different. The Court of Appeals used the WDSI case, which is a fairly broad interpretation of what a government function is. So they kind of look to whether there's payment of public funds to go to the project and to what exactly is happening. The administrative law judge had a more narrow view and was looking specifically to whether a statute required something to happen. So like in this case, they decided that, the ALJ decided that in building a school, there's nothing in statute that requires a contractor to contract out for architectural consulting services. And so therefore, he determined that wasn't a government function. So the analysis can go either way, depending on who's doing the interpreting.
Representative Portman.
Mr. Chair, so then it sounds like from the answer I'm hearing from both, this subdivision applies to basically all contracts, any contract that the government enters into with any entity.
Representative Quam.
Thank you, Mr. Chair, and I'm not sure which would be the best person to address, but I'm interested in understanding this decision opens up a scope of exposure on existing contracts. How will this bill impact that scope, and is there something additionally that could be done to this bill to minimize the scope of exposure?
Okay, well, Representative Quam, I think that's a good question. This is my bill, rather than have me answer it, why don't I have Ms. Byer-Kopensky take a shot at that?
Mr. Chair, Representative Quam, part of the issue in data practices is when you have a court case, you have to prove damages. So someone would be able to prove damages, actual damages, real one. I went to my therapist 100 times because I didn't get this. You'd have to show real damages. There's also the ability to action to compel compliance. So it's certainly that someone could go to court and say, I order you to amend this contract and comply with the Data Practices Act. It is really difficult to say really kind of how much liability would be out there.
One short follow-up. Is there any suggested thing that could mitigate some of the exposure, or are we just looking at this bill, yes or no, whether it's needed?
Well, I would tell you, Representative Quam, in my opinion, no, the cat's out of the bag. At least from between 2007 2013, when the court decision came down, when apparently people's antennae went up. Those contracts have already occurred, and it depends on whether or not there was violations related to them, and those would have to be independently ascertained through legal action to find out if there is exposure. But this bill itself is intended to correct that, so there is no further issues going forward. That was the original intent. Representative Quam.
And the last follow-up clarification, is there the possibility that something in this bill could cause an increase in the exposure by admitting that something was overlooked in the initial statute?
Okay, well, that's an interesting, and it's more probably a legal question related to rules of evidence and remediating past, I don't know, I haven't done civil law in a long time, but how about Mr. Gehring? Can you answer that?
Mr. Chair, Representative Quam, I think Chair Lesch is probably right in his analysis of how it would apply to a specific case. I mean, the bill is written pretty broadly, and it's not written to a specific factual set of circumstances. So the court would have to interpret it, and you know, it's a general law that could be applied to a specific case, and it'd be up to the judge to decide how it would apply in that case. Normally,
Representative Quam, you can't use, like, say, a corporation's action in correcting an incorrect action as evidence that, in fact, they were liable in the first place. But I would not know how that would apply to government with the passage of a law that amends that. So I think it would be based upon an individual case. Representative Polberg.
Thank you, Mr. Chair. Ms. Byer-Kopensky, as we heard this bill in committee, I have an image of you holding up a piece of paper and saying all state contracts contain this information, and so this isn't an issue for us. Then I started being bombarded by health plans and others all, excited about the bill and its ramifications, and I couldn't figure out if in fact they were doing government functions in contract with a state agency, why they weren't already complying with the standard. Are there certain instances, and if so, if you know or are aware, where the departments have the authority to not follow this provision and or modify what portions of the data practices apply to somebody or entity that contracts with the government, outside of standard things already in Chapter 13, trade secrets, et cetera?
Ms. Barker-Pinsky.
Mr. Chair, Representative Holberg, and when I was testifying, I had pulled the shell contract language that the Department of Administration distributes for all agencies to use. We had heard a specific question around the contract with health plans. So I had my folks pull the one for the state health plan, which is CGIP, pulled that contract out, looked at the language, it matched the shell, and that was what I was testifying to. And it wasn't until sometime later where we became aware that Department of Human Services language varied and included some of it, but not all of it. And as I mentioned earlier, this wasn't a provision in, while the shells all complied with the law, this wasn't a section that was tagged to be verified every time it came into the Department of Administration, because the state of the law before November was it didn't matter what it said. The law was going to be inferred. So people didn't have to take that extra step. But since November, that is exactly what admin's been doing. Any variance as to that language is being verified to ensure that it does fully comply. And I've already handled a couple questions from my admin colleagues around, would this be okay?
Representative Holberg.
Madam or Mr. Chair and Ms. Byer-Kopinski, but it's my understanding that some of these contracts even went so far as to reclassify data or make provisions of the contract in conflict with Chapter 13, in which these entities, health plans specifically, relied on for data protection outside of Chapter 13 because it was in the contract. In your opinion, did the Commissioner of Human Services have the right to put those provisions in a contract?
Ms. Byer-Kopinski.
Mr. Chair, Representative Holberg, I can certainly get back to you with some more information from folks who are much more in detail around the contracting process and how much flexibility and delegations that various agencies have in doing their contracts. It may be that the Department of Human Services can respond to that as well. But I know that there is frequently negotiations between the Attorney General's Office, Department of Admin, and agencies around changes to the boilerplate language in accordance with whoever they are negotiating with.
Representative Holberg.
Maybe I can get at this a different way. Are you aware of any provisions of Chapter 13 that give commissioners discretion in applying the chapter to their functions?
Ms. Byer-Kopinski.
Mr. Chair, Representative Holberg, and that's what I wanted to address earlier. People have been describing it as they were losing or gaining discretion. The requirement that it be in the contract was already law. There wasn't discretion about choosing to leave it in or out. That was making a decision to violate the law or not to violate the law. That wasn't discretion. Whether or not also, when you get a data request, every agency has their own data practices silo. So my analysis around trade secret might be we would hope that it's going to be consistent agency to agency and county to city. It may not be, and it really depends on the arguments that are being made by a vendor and how thorough they are and whether or not you agree with them. People have different standards around that.
Representative Holberg.
Mr. Chair, I'll try one more time here. I'm not speaking specifically to the court case. I'm speaking more broadly in that when you have the Commissioner of Human Service entering into contracts, I'll be specific to health plans. Do they have an authority given to them by law, by the legislature, to change classifications or data or use by virtue of a contract that's not specified, a classification that's specified outside of Chapter 13? In other words, if there's a business practice that they view that is not covered by trade secret protection, they classify that information as being non-public or private on individuals, and either in conflict or at their own discretion by virtue of a contract and not Chapter 13.
Ms. Byer-Kopinski?
Mr. Chair, Representative Holberg, as you know, there's classifications that are in state and federal law, and certainly there are some where there is more flexibility in how you do that analysis. Certainly whether or not parties agree that something is educational data or trade secret or whatever, I mean, different people can do different analysis around that. They can't create their own classification of data. They are bound by what is in state and federal law, but often, especially with federal law, you look at it and say, does this classify this data in my hands or in your hands? So there is always legal analysis on whether or not a classification protects data and from whom.
Okay, and if I might, just one more question, and I'll be quiet. What have you and your department done in reaction to the court case, specifically to address this new Supreme Court enacted standard? Are you, training all the people in the departments? Have you sent out news releases? What are you doing to fix this problem that, in my opinion, has been created by the courts?
Ms. Byer-Kopinski?
Mr. Chair, Representative Holberg, we have information pieces we provide. We do provide training. We also have web resources for people. We have certainly, the Department of Admin itself is verifying that, kind of contract language meets the requirements. We are also providing that sample to others, and we've had certainly news media folks saying, hey, what does some nice language look like? Can you share it with me? So we've been doing it in a variety of ways to help people with that, and we'll continue to do so.
Thank you.
Representative Huntley?
Mr. Chair and Ms. Byer-Kopinski, I have two questions. One, you mentioned the word trade secrets, and could you define that and kind of explain that to me?
Ms. Byer-Kopinski?
Mr. Chair, Representative Huntley, many people are familiar with the term proprietary data, and that is one that federal agencies have the ability to use. Minnesota law has a much stricter standard, which is trade secret, and it's got a 4-part test. It comes from a vendor. They take steps to protect it. It has some economic value by being shared. I don't have all of it sitting right here, but if you looked at it just broadly, we have a tougher standard to meet than many vendors are used to whenever they have done work for another state or for the federal government.
Representative Huntley?
And Mr. Chair and Ms. Byer-Kopinski, in a different, let's suppose the state has a truck and they want to get it fixed and they can't fix it themselves, and they send it to some truck repair place. How much information can they get from that company as to how the company spent the money that we're paying them? Like, how much did they pay their employees, so on? How much did they pay for the parts that they had to buy? That sort of thing. What can we require of them to give us?
Ms. Byer-Kopinski?
Mr. Chair, Representative Huntley, and that is what I was saying, that the answer is always, it depends. Like, did I pay $29.95 for an oil change? You're going to get to know I paid $29.95 for the oil change, and $5 of that was the environmental fee. It really is going to depend on what I'm contracting for and the data that is created associated with that. If I do something like that, it might be the invoice I get from the mechanic is the only data that was created as a part of the contract. There's going to maybe be a copy of the check that I spent to pay them, and there might not even be a contract to get my, tire repaired or get that oil change. So it really is going to depend. And the law is built so that no matter if there's one page of data or lots of data, that it's going to cover, kind of what you got. But it really depends on what government is contracting and how they contract. It depends.
Well, Mr. Chair, I'm just concerned about trying to understand what we can really get and what we shouldn't get.
Representative Albright?
Thank you, Mr. Chair.
I'm not sure who would answer the question, but I'm going to maybe back up a little bit because it seems to me that we're dealing with contract law. And this is about, in my opinion, and this is where I'm looking for people smarter than me to help me out, but it seems to me like the state is unilaterally changing the provisions of a contract. Would that be true?
Ms. Byer-Kopinski?
Mr. Chair and members, I think from the point where the Court of Appeals said, even if your contract is badly written, we're going to infer this term into it, I think that's the point where the courts and then the Commissioner Advisory opinions were saying, we're going to rewrite your contract and we're going to infer all kinds of terms if you don't have them in there.
Well, and Representative Albright, maybe Mr. Gehring could explain this better, but all contracts are subject to statutory law, so therefore if there is illegal provision, the contract is either void or voidable. So contracts are subservient to statutes themselves, but maybe Mr. Gehring can tell me if I'm wrong on that.
Mr. Chair, yes, I think that's correct. And the only thing I would point out about this statute in particular is that the obligation in the subdivision is that the government entity has to include the terms of the Data Practices Act in the contract. So it's not a statute that affects any other terms of the contract. It's a condition that if the government entity is going to enter a contract, it has to require that there be terms related to data practices in it.
Representative Albright?
So, Chair Lesch, to your point, does that then infer that the contract is or is not null and void based upon the non-inclusion? Because I heard that information has to be written into it. So does that infer that it has to be agreed to again? Or because are we dealing with mutually agreeable terms, back to contract law, or is it just an amendment to the contract that would allow the contract to survive going forward?
So, Representative Albright, based upon the court's reasoning, the contract is allowed to survive going forward, and they would not have voided the contract or permitted an individual party to the contract to void it. My expectation is the legislative intent of this was that the language as stated in the statute would presume inference in the contract. I think everyone around the table would have said that. Well, maybe not everyone, but most people in the legislature. But the court said, well, no, you've got to write it in there. And if you don't, then, you don't, it's not that the contract is void, it's that the expectation of the public nature of the information under Chapter 13 is not there. You don't get the info. So it more relates to the problem with getting the data than it does to with the contract itself.
Thank you.
Representative Liebling.
Thank you, Mr. Chair. And first of all, I thank you, Mr. Gehring, for this memo, which I think is very helpful. And just looking at the language that you've given us of Subdivision 11 here, I think that to me, it's very clear that what the intent was, even though the language was a bit inartful. If you look at the whole thing, I think it's very clear that this was a requirement, and not just a requirement, that the section here doesn't just relate to, oh, you had to write it into the contract. It also tells you what the underlying law is. And so it makes it really clear to me that the statute, the bill we're looking at really is just a clarification and not anything new. A couple questions I wanted to ask, and I think other members have been kind of getting at this, but since sort of the reason we're here and the reason we've got the joint committees here is because of the questions about how this relates to the health plans and other health entities. So I just want to ask kind of point blank if you can help us, or to the degree you can help us. So first of all, is a health plan performing a government function when it contracts to deliver prepaid medical assistance? I think that's one of our core questions here. And the second question would be, if a hospital or other provider has a state MA contract, how much of their data, of the data of the entity, is then disclosable under Chapter 13? I think that's what Representative Huntley was kind of getting to with his car analogy, but this is really the direct question, I think, so it's twofold if you've got those two.
Ms. Byer-Kopinski.
Mr. Chair, Representative Liebling. As to a government function, I mean, I think that's, as we mentioned, that area law is not as clear as it could be. There are some folks who believe that anytime government money is spent, government money is spent. It doesn't matter if it's I'm providing public education, doesn't mean if I'm providing, kind of public services, or if I am just hiring groundskeepers. That, it doesn't matter. It's any of government's functions. As to whether or not, when the state or anyone contracts for health insurance, will I get to know, and it's, $1,000 per person per year. Will I get to know that? Will I get to see the claims that come in for each individual person? No, that's already classified by, welfare data, 1346. So you're not going to be able to see individual patient numbers, but you'd get to see the state is paying for, 30,000 people at $1,000 a month. There's certainly an argument to be made that how they determine what is that rate, which includes actuarials and their claims experience, there is an argument that that is trade secret. I have not seen a request for that. I have not seen an analysis that anyone's put together around that. It is certainly arguable. And so some folks feel comfortable that existing law provides enough protection for the kind of data that folks care about. There are others who do not agree that it's, going to protect them from any litigation around this topic. And I don't know that anything is going to protect people completely from litigation or the potential for litigation. That someone might not agree that the data is trade secret, and would a judge agree? I don't know.
Well, thank you, and thank you. I think that, I know there's an argument. That's kind of why we're here. It's because there is an argument that this is
right.
That certain of this data is protected. I think we are mainly talking about data around what the plans pay the providers. I don't think anybody's arguing that individual patient data would be opened up, because obviously that's protected under other provisions. But I think the main argument, although we'll wait for the health plans to testify and tell us exactly what they're concerned about, but I think that is kind of the core of the matter. But then the second piece is about the provider themselves. So if a hospital provides services under a state MA contract, how much of their data, obviously, again, we're not talking about individual patient data, because that has, or data that has other kinds of particular protections. But how much of their data would be, under current law, available to a data request?
Mr. Chair, Representative Liebling, I don't know.
I have to that point, Ms. Byer-Kopinski. Can I, when my daughter was born, was in the hospital, and I saw her mother get charged like $40 for 2 Tylenol. Could I find that out under the laws of this now? Why that was? Okay, that's a rhetorical question. You don't have to answer that. Representative Hortman.
No, I don't have one.
Any other questions? And Representative Loeffler.
Well, thank you, Mr. Chair. And to the point that Chair Liebling was making, to me, the issue of government function is under our contract or agreement with the federal government for medical assistance, we have all kinds of obligations, and then we extend those into how we work with all the vendors. And the typical way in our statutes of providing medical assistance is fee-for-service, and in which the Department of Human Services sets the rates, vendors enroll. It's a very transparent sort of system. We have authorized in statute demonstration projects, and they still use that title, which is the contracts with the managed care entities. But to me, there's no question of a governmental function, because we are still doing a demonstration of an alternative way of purchasing, but they're both the same function, whether it's a physician or someone is providing a service under fee-for-service and being reimbursed that way, or we have a different management system. And the concept was that adding a management system in was going to reduce costs and create efficiencies, and I think it's always remained in statute a demonstration project, because we're still debating whether the data is there on all the outcomes, and I think some of them are very clear that we have really made some real improvements by using this managed care system. But I think that to me is the question, and does that help you clarify the issue of governmental function in any way, or is that something we need to ask others?
Ms. Byer-Kopinski.
Mr. Chair, Representative Loeffler, I've had a much simpler approach. I'm on the side of any of its functions means you can follow government money. Over the last couple of years, we started to hear more arguments like when the state provides me health care, they are doing it just like any other employer, like any other business. And it was really a new argument that I had not heard before. So some people do believe you can start to make distinctions on, did the government ever do that themselves before? Like, people have a whole different ways of how they would argue around government function. But there are clearly some where you would say, when we are doing some of our social services, clearly that's a government function, even in the most strictest sense. Whereas I'm on the other end of the spectrum saying it's government money, it's all, this provision is about all contracts and all grants. So,
thank you.
Thank you very much for your testimony. There being no other questions. Oh, Representative Lane.
As you were speaking about the state providing health care as a business, and then Representative Loeffler had talked about them as demonstration projects, we did that function in the state. And then we said, well, maybe it can be done cheaper if we give it to somebody else to do. Let's find out. Let's do a demonstration project. So it was definitely government function. And we are still, as she said, calling them demonstration projects, but we don't know if we're saving money really because we can't get at the data. That's the problem in my view.
Any other questions or comments for Tim Albright?
Thank you, Mr. Chair. I just have a question with regard to, based upon the date of enactment for this bill, my understanding that this would be prospective. What would the obligation retrospectively to contracts already agreed to?
Ms. Byer-Kopinski.
Mr. Chair and Representative, it's really interesting because the way sometimes passage of data classifications have what looks like a retroactive effect because you look at the classification of data on the day you get the request. So we've got lots of contracts out there, and I can come in on August 1st and ask for the last years of your 20 years worth of your contracts. And we're going to do an analysis on whether or not that data is public or not public today. So that's something that, we've had that, especially in our discussions around personnel data. We've got settlement agreements that were negotiated 10 years ago for big payouts to employees. And then the law changes, and I can go back and look at that 20-year-old agreement, and I'm basically the legislature. You have the power to undo that agreement and decide what's going to be public today. So that's how data practices works. But I'm not exactly sure as to, with this provision and you fixing it, whether or not, do we still have a window of contracts that if it's missing, it won't be inferred, or whether or not you need to write something specific to be able to make sure that if there are any contracts out there that don't have the language in them right now that are still active can get fixed. I'll think about that.
Thank you. Representative Albert.
Thank you. And I think this goes to my earlier questioning because it is an issue of contract law. You've got people that have mutually agreed terms in these contracts, and now you are imposing upon them a unilateral decision to change the contract. You're setting yourself up for a breach of duty based upon the contract provisions that are not applicable under this piece of legislation. So I think what you're doing is actually setting up a legal confrontation between, as might be implied, those contractors that were to MA contracts in the state of Minnesota and the people that actually now rely upon them for health insurance themselves. You are putting, it could be inferred that you're putting the state of Minnesota and the people that rely upon MA in a double jeopardy situation for whether or not they have coverage or not, or whether they are going to be obliged to provide information on those people back to the state or not.
Ms. Byer-Kopinski, then, go ahead.
Mr. Chair and Representative, I want to make clear this is not the Department of Administration's bill. We are providing technical assistance. We're not supporting or opposing the bill. We're trying to make sure that the language does what you want it to do and so that it doesn't have any unintended consequences. Whether or not you adopt this policy or not, whether or not you're concerned about what the concurrence said about creating a roadmap for vendors to be able to avoid having data exposed, completely, that's why I said you guys get the tougher voices, and that is not where we weigh in.
Was this to this point, Representative Scott? Okay, go ahead, Representative Scott.
Thank you, Mr. Chair. I'm wondering if Mr. Gehring might have an answer on that. Would those past contracts be quote-unquote kind of grandfathered in?
Mr. Gehring.
Mr. Chair, Representative Scott, I guess it's sort of an open question how the past contracts would be affected. I think if the bill were to move forward, probably it would be helpful to add an effective date that clarifies how the legislature intends it to apply to contracts that already exist and to new contracts that are entered.
Well, and Representative Scott, we have some other people in the room that may want to weigh in on that question too. So keep that in mind, folks, that question. Representative Liebling at this point.
Yeah, thank you, Mr. Chair. And before this meeting, I was given a copy of the general Minnesota Healthcare Programs Provider Agreement. And, of course, this is the provider agreement. I hope that DHS will be able to talk to us about the plans, what is in the contract that they have. But I did notice in this, there's nothing about Chapter 13 explicitly, but there is a requirement in here that the provider who's signing this contract determine the applicability to the provider of any other state or federal laws and ensure compliance with those laws. So I would say that at least as to the providers, I know this is a very broad term, but if we're talking about, this is a pretty detailed undertaking, contracting for MA services and so on, and it involves a lot of state and federal law. And so I would say that given this provision, there isn't any excuse. I don't think anybody could really come in and say, well, since we didn't know about the law, it's not part of our contract, or we didn't have that obligation, even if it wasn't in the contract. That would be just my take on this line. It sort of puts people on notice.
Representative Albright.
And to your Representative Lesch, to Chair, Representative Liebling, doesn't that just infer then that they would be prospective only and not retrospective? Because to your point about not knowing about what was futuristically put into law, you're now obligated to be governed by new law that was 2 years old. I think that's a bit of a stretch in terms of obligating yourself to not knowing what's in the future.
What I'd like, Representative Albright, there are some other folks that are going to weigh in later on, both proponents of the bill and opponents as it's written. I think it'd be worthwhile to hold off and hear from some of them before we come to our own conclusions about it, and then after that. Does that sound all right?
Thank you, Chair Lesch. And just to the point of the document that Representative Liebling is referring to, I was wondering if we could get copies of that distributed to all the attendees.
Sure, it's got kind of my notes on it. That's all right. Isn't that kind
We'll get another copy.
No, it's fine.
Okay, thank you for your testimony, Ms. Byer-Kopinski.
Thank you.
The next person to testify is Rich Newmeister.
Mr. Chairman, for the record, my name is Rich Newmeister, and I thank you humbly very much because I have to scoot. Let me just start from the beginning. In the mid-'90s, there was a huge emphasis of where contracts were going out, where government couldn't do certain things. And on the behalf of government, contracts were going out, spending millions, billions of dollars now over the last 15, 16 years of taxpayer money. What was beginning to happen in the 90s, particularly like someone myself who interacts a lot with a lot of the public, reporters and all that, they were saying, oh, we can't get this information because it's being held by a third party. I'll give you an example. As many of you know, hundreds of thousands of dollars are being spent on consultant fees for something, whether it be for economic development, whether it be a recommendation of a proposal, but a very broad way. What would happen is the government entity would get a 200-page report with a lot of recommendations that would have impact on people's neighborhoods, their lives, and they want to know, how did you get to this conclusion? What kind of data did you use? And what did the government entity say? I'm sorry, Mr. Newmeister, Mr. Reporter, Ms. Jones, we don't have the data. It's held by the private party who we have a contract to that nobody knew about. The employee, when a job hunt or whatever, when a third party does some background kinds of checks or whatever. Oh, the government, well, we don't have the raw data that was used for the report. We're just being told that you're not going to be hired. But they couldn't get the data to see. And one of the other things, what it affects very directly, are parents. Parents, as always, wants to know who are the employees that are involved with their kids, particularly bus drivers or whatever. The school district may not have the whole names, but maybe a parent or two wanted to do some background information under current law, under 1343. They could. They could find out the name of the person, at least some of the stuff that is now for public employees they could. And if they wanted to on their own with the name, they could do a background check if they wanted to. So the broad aspect of this is happening, and people in the public were being turned away. There was a legislative commission formed. I was involved in that. I was appointed by the other body, Gene Pulowski and other people. Other people were on that. That's where the recommendation came from, to say, you know what, it's important those data practices provisions be a part for the public, have a right to know what's happening, where their money and programs are being used on the government's behalf, for the public transparency and accountability aspect, but also is just as important for the privacy. As you all know, in human services, you contract out to a lot, school districts too, and you want to make sure that Chapter 13 applies. Mr. Chairman, members of the committee, I encourage the way the bill is drafted is the one I encourage you to go forward with. Now, the health plans are going to raise their issues like this. The issue of trade secret, and I'll give you an example of how this is done with trade secret. In 1991 and 1992, I opposed caller ID for a number of reasons. Northwestern Bell, or whatever the heck they were called back then, gave a lot of information to the PUC, or the, whatever it was called, Department of Public Service at that time. I said, I'm going to take a look at all that stuff. But Northwestern Bell, or whatever it was, says, no, you can't, because it's all proprietary, and all that sort of stuff. Well, I said, well, there's trade secret, 1337. And in our state, and U.S. policymakers beforehand, and have continued ever since for the last 30 years, says it's important for that when folks do business with the state, and when they use trade secrets, proprietary, because what happens a lot, people hide behind those things. So I made the request. The AG at that time, I believe his name was Gary Cunningham or somebody, he's still around, took a look, and about 90% of what was filed as supposedly proprietary information, it was public, it had no economic value, but what I was able to do to gain from that was information to where I could, as a lowly citizen who's been around a long time and tries to do things, to say, I think caller ID is a bunch of hooey, and if you're going to go with it, when you call a government agency who has a caller ID, that they don't know who's calling. As you all know, now we have built-in caller IDs, and you know who's calling you all. But you get the point. So, Madam Chair, or Mr. Chairman, and the tri-chairs, this is a very important bill. Public accountability, transparency, and all this bill is just trying to put what the law was based and what folks have been doing and going under for the last 15 years. Mr. Chairman, members of the committee, thank you very much. I just wanted to give you a real citizen kind of perspective on these things. And many people like me use this to go out to find out what private entities are doing all the time when they're doing stuff on behalf of you. And I consult and work with them, reporters and all that all the time. It's a very useful law when sometimes you may not be able to see things, but the public can. Mr. Chairman, thank you very much for the few moments of your time.
Thank you, Mr. Newmeister, and we're going to hold off on questions from Mr. Newmeister because clearly he has to go. There you go. Mark Ampeson. Mr. Ampeson, I don't know if you were on your list if you requested to testify, but I asked you to come up to explain it because you were closely involved with the decision as it came down, and
in November, and if you could explain your involvement with it.
Mr. Chair, members, Mark Antonson, attorney for the Newspaper Association. I litigated the Timber J case through all those horrible steps and stages of the process that Mr. Gehring summarized. Almost everything that I could usefully tell you about this bill has already been said. And given the time and the date, I'm not going to repeat that. I would just like to make 2 or 3 brief comments to focus some of the key parts of the issue. Number one, this started as a simple bill, and it is still a very simple bill. What has caused the complications is the underlying statute, 1305 sub 11. As you've all now begun to appreciate, that's not a simple statute. It's a very complex subject area of law. But the bill itself is simple. And the reason it's simple is that, as other witnesses have said, for almost 15 years, both the courts and the Information Policy and Analysis Division, in more than 10 different advisory opinions, consistently stated that if a government contract did not have the notice in it, the notice was nonetheless inferred by law into the contract. And that is, again, all this bill would do, is restore that. Final point. There's been some discussion about potential legal liability for government agencies if they don't have in their contracts the data practices notice. This is just my personal opinion. I am an attorney. I think there's a considerable potential liability for government agencies that don't have this notice in it. Because, for example, let's say a county didn't have the notice in. Under the current Supreme Court ruling, the government contractors with that county would not have a duty to protect the private data they obtained from the county. And if they then potentially disclose that data, who does the injured party come back knocking on the door of? The contractor, certainly, but they would have, I think, a legitimate claim against the county for failing to comply with this statute and put the notice in the contract. So of all the things Chair Lesch's bill will do, I think plugging the dike of a potential privacy claim is the most important. And after all, if you look at the legislative history of this bill, of this statute in 1999, it was mainly enacted to assure that government contractors protected private data that they came into the possession of from government. A secondary benefit is public access, no question. Thank you, Mr. Chair.
Questions for Mr. Anderson? Representative Clark.
Thank you, Mr. Chair. And I'm just trying to be practical here based on the advice you just provided us. Are you suggesting that counties go back and redo all their contracts?
Mr. Anderson.
Mr. Chair, Representative, yeah, I think they absolutely should. And in fact, as Lori Beyer-Krupensky testified a few minutes ago, because of the Supreme Court's decision where you can't infer the notice anymore, there's a real move afoot throughout the state to do exactly that. But it will be done imperfectly, and it will be missed by some government agencies because, let's face it, this isn't the most well-known statute in the world.
Mr. Johnson.
Thank you, Mr. Chair. Again, and I don't know if you're the right person to answer this, but that implies my question is, what does that process look like? How many contracts are we talking about? How expensive is that, and that sort of thing?
Well, Mr. Chair, Representative, I think there's a lot of contracts at the local level. I think at the state level it's fairly rare because admin has traditionally had a role in promulgating a contract form. But if you look at this case, the Johnson Controls case, Johnson Controls, which entered into the contract with this school district in St. Louis County, is a Fortune 500 corporation. It has very fine, skilled lawyers. It drafted basically this contract, not the school district. And it didn't include the notice. So if it can happen there, it can happen anywhere.
Representative Scott.
Thank you, Mr. Chair. Mr. Amundson, so if we adopt the Lesch bill as law, does that then would release from liability the contracts?
Mr. Anderson.
Mr. Chair, Representative Scott, no, I don't think it would release anybody from liability, but it would make clear that it would eliminate, I think, the claim that the government agency was negligent in not including in the contractor's contract the required data practices rules. That's what it gets to.
Okay, thank you.
Any other questions for Mr. Anderson? Representative Johnson?
Thank you, Mr. Chair. And then that raises another question. Then what would that negligence mean in real terms?
Mr. Anderson?
Well, Mr. Chair, Representative Johnson, it would mean many different things depending on the type of incident that occurred. But take Mr. Neumeister's example of the school bus contractor who is in possession of very sensitive data about hundreds or thousands of public school students. And let's say that contractor disclosed a large quantity of that data about the students for some commercial or other purpose. I think that's a pretty formidable invasion of privacy claim that goes first against the contractor, but then to the school district, potentially.
Representative Gruenhagen?
Oh, thank you, Mr. Chair. Couldn't you amend the contract with the school?
Representative Gruenhagen, can you speak into the microphone? Speak. Thank you.
Yeah, couldn't you just amend your contracts like a school district, just amend the contracts that are out there, like with a private bus organization?
Mr. Anderson?
Mr. Chair, Representative, yes, you could and should, but the problem here, and it's come up in some of the questions, is once a contract has been entered into, if the contractor doesn't want to amend it, they're not, I don't think, under a duty to do it. The good news here with the bill going forward is that most of these government contracts, and I'm no expert, tend to renew or expire on a fairly short cycle. So in a relatively brief period of time, if this legislation were enacted, you'd get back to a stable position.
Representative Morgan?
Thank you, Mr. Chair. I don't want to short-circuit the chair's agenda by any way, shape, or form, but I believe that the key question, the reason we're here today, is to hear about the impact of this on health plans who have contracted with the government. Are we going to, can you give me a timeline, Mr. Chair? I'm sorry.
Well, I'm not sure if I understand your question. A timeline as to when we're going to get to talk about stuff you want to talk about, Representative Morgan?
Well, Mr. Chair, I'm just interested in, I haven't had a lot to eat lately, and I'm wondering when we're going to talk about the health plans.
Okay. Well, Representative Morgan, after this, I have on the list for testimony Mr. Gemberling, Mr. Ailing from the Minnesota Coalition of Government Information, and after those testifiers, I have Catherine Commit with the Minnesota Council of Health Plans, whose testimony I imagine will revolve more around health-related contracts.
Thank you.
That said, the bill is here not just because of health contracts, Representative Morgan. Chapter 13 includes all the contracts in the state of Minnesota. And so when the health plans brought up their concern, they had major concerns over how Chapter 13 operated insofar as it impacted their own contracts under Chapter 13. However, modifying law to suit the interests of the health plans would have implications for all the contracts, which is why we're talking about Chapter 13 kind of in more general sense right now as an introductory measure. But with that, are there any other questions, Representative Scott, and then Representative Holbert?
Thank you, Mr. Chair. Representative Morgan, if you're hungry, perhaps Lori's Representative Halverson's son would share his Swedish fish with you.
I just stole a little Hershey bar from Representative Hortman, so I just might take you up on that, Representative Scott. Thank you.
Representative Holbert.
Thank you, Mr. Chair. Mr. Anderson, I've had plenty of conversations with the health plans, and I'm of the belief that I'm not sure that the court case is really their problem as expressed. I'm not sure that they're not already protected under Chapter 13, and as somebody who's really reticent to carve out special groups, I would rather have Chapter 13 apply across the system than to have all of these exceptions. It's really hard to convince me why the term I use, they're so special, that they should have an exemption that other contractors or subs would not have. As you had conversations with them, how much of their issue do you think is directly related to the court case, and then how much of it is to other factors? which I understand is a Commissioner of Health and Human Services that may be implementing contracts that give them protections that aren't in Chapter 13.
Mr. Amundson?
Mr. Chair, Representative Holberg, in my opinion, and again, it's just my opinion, but I have thought about this issue more than most people because I litigated the dang thing for more than 3 years. In my opinion, the court case has zero impact on the health plans and their concern. Okay? Their problem and their concern is purely a product of existing law. Whether this bill passes or not, that problem will be the same. Now, having said that, and not to disagree with you in any way, I have had many, many conversations with representatives of health plans, and I have developed some sympathy for their concern. I think it's at least an arguable issue, but it's not because of this bill. They may need some data practices classifications separately to protect some data. But whether this bill is enacted or not will have zero impact on their issues.
Seeing no other questions for Mr. Amundson, thank you for your testimony.
Thank you, Mr. Chairman.
Mr. Amundson. Don Gemberling and Matt Ailing of the Minnesota Coalition on Government Information.
Mr. Chairman, Matt isn't here, so it's me. Excuse me, I'm working on a cold, so bear with me. My name is Don Gemberling. I'm with the Minnesota Coalition on Government Information, which basically is an organization that focuses on trying to keep as much government information available to the public as possible and to have government processes be very transparent if that's possible. For those of you who don't know me, and as I get older, I realize there are more and more people in the legislature who never dealt with me when I was here for 30-odd years. I used to have Ms. Byer-Kopensky's job, okay, and spent a lot of time helping people work through these issues. And as with no insult taken, I actually drafted the language of Subdivision 11, okay? So I did that because I was principal staff to the commission that Rich Neumeister mentioned, which was called the Information Policy Advisory Task Force. It was a joint legislative executive branch commission, okay? And it looked at all kinds of issues. I can only tell you with the strongest possible voice that what Mark Amundson just told you is absolutely correct. It does not need to be qualified by, it's just my opinion, okay? There's nothing in this bill that does anything to the health plans, okay? When I started hearing about the buzz about the problems the health plans had with the bill, I finally called the health plans and said, what is your problem? Because as I told you, part of what I do is I help people sort this stuff out because it is complex. And a problem was described to me, and I said, oh, okay, fine. I understand that. So here's what I'm going to do. I'm going to draft you some language that addresses that problem. Now understand, because the organization I represent is in the openness business, I will draft you the language because I'm a good technician. And I'll probably end up opposing it, okay? But at least we'll have something that brings the issue to the fore, and we can deal with what the real issue is. Because frankly, I've now heard about 5 variations on this issue, okay? So I don't know how policymakers get their arms around something if you get 5 different descriptions of what the problem is. So I sent that off to the health plans. I put a note in that said, if I screwed this up, give me a call. That was about 2-3 weeks ago, and I haven't heard a word. So I thought, geez, fix that one. Wrong. So, you know, I understand part now, and frankly, about 4th or 5th hand of what the problem is. And when I looked at this agreement, thankfully provided by Representative Liebling, I get a better sense of what the problem is. There are actually 4 different contract provisions in the Data Practices Act. Mr. Gehring wrote a wonderful piece summarizing 2 of them. But the 3rd one is there's a provision in the welfare data section that says that you're in the welfare system, you're part of the welfare system, blah, 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 including DHS, counties, et cetera, but you're also in the welfare system if you're a private entity to the extent that's specified in a contract with any part of the welfare system. Okay? So when I look at this agreement, I say, oh, Clause 21, Subclause A, Part 1. The agents of the provider have to comply with the Minnesota Government Data Practices Act, and here's the interesting words. In particular, Section 1346. Now, does that mean that's all they have to comply with? And frankly, I don't know. Okay? I could tell you I didn't draft this. So I think that may be part of what's lurking out here as what the real problem may be. Now, some of you have asked questions about what does this do with existing contracts. Let me give you an example. One of the kind of troubling calls I would get when I was working would be from some small social services agency, private social services agency, that had contracted with part of the welfare system to do whatever functions. And in those contracts, and Hennepin County perhaps has the one that's the most clear and plain, it would say very clearly you have to comply with the Data Practices Act. So this executive director of something that had like 4 or 5 employees would call me and say, you know, we signed this contract because we want the money, but what does it mean to comply with the Data Practices Act? Okay? Reasonable question. But then when I began telling them what it meant to comply with the Data Practices Act, then they were, oh, okay, that's what we signed up for. Because you have to do a lot of things to comply with the Data Practices Act. So I'm real anxious to hear what the real problem is. And, you know, we're always trying to help people sort out those real problems. And to the extent that we can help you with that, that's good. But to reiterate, Representative Lesch's bill just does a couple of very simple things to clarify what happened in the Johnson Controls case, and that's all it does. Thank you.
Thank you, Mr. Gemmerling. Question for Mr. Gemmerling, Representative Holberg.
Thank you, Mr. Chair. Mr. Gemmerling, I tried to get an answer out of Ms. Byer-Kapinski, and given your experience, is there anything in Chapter 13 or elsewhere in law that gives the commissioner discretion in applying Chapter 13 by contract?
Mr. Gemmerling.
Chair people, I'm surprised they haven't called you the troika yet. Representative Holberg, from time to time we would get the following question. Can we contractually do something other than the Data Practices Act? And the answer always was, no, you cannot. Okay? Now, the language that's in the welfare data section that I just quoted to you, essentially, does, I think, raise an interesting issue. Okay? The other question that we got a lot was, and this always came from state agencies, we're dealing with a vendor, and the vendor doesn't want people to get at their proprietary information. So we worked with the Attorney General's office to put a clause in contracts that says if anybody asks for information about the vendor that we don't know what the classification is or that we don't want to fight about, the state agency agrees to contact the vendor, let them know that somebody's asking for the data, and then the real parties of interest can have a fight. Okay? And I talked about that provision with the AG's office a number of times, and my basic position was, you're the AG. You represent those people. I don't represent them. If that's what you want to do to deal with those kinds of issues, fine. Okay? So that's what I know about those kinds of things. Oh, one more thing. Clearly, and I've taught classes on this, you cannot write a contract that classifies data. You just can't. And the reason for that is very simple. The Data Practices Act says the data in this state can only be classified as not public because of federal law or Minnesota statute. Okay? And we've always interpreted that to mean a statute enacted by the legislature dealing with the data.
All right, thank you.
Representative Albright.
Thank you, Mr. Chair. Mr. Gemberling, I get back to the question of under the proposed legislation, it understandably would, as you would put it, put the finger in the dike with regard to contracts prospectively. but in your opinion, does it rectify and repair contracts retrospectively?
Mr. Kimberly. Mr. Chair, Representative Albright, I, like most of the people you've heard so far, I just disagree with the Johnson Controls decision. And just so you know, I was on the other side from Mr. Amundson on that decision because I also do some consulting. Part of what I don't understand about the situation is when this legislation was originally enacted, okay, it went through the entire legislative process. And I kept waiting for the private sector lobbyists, of which all of you know there are hundreds, if not thousands, to come and say, does this really do what I think it does to us? Does this make us, if we contract with the government, subject to the Data Practices Act? And in all those months and weeks, I only had one lobbyist who ever came and asked that question. Okay? It then became law, and as Mark Amundson has pointed out to you in the case of the Johnson Controls situation, we're talking about a large company with good lawyers, and why the private sector hasn't woken up to the fact that this language does what it does since the beginning of the discussion in 1998, I don't understand. So I think that if people have to go back and redo contracts, they should have been doing it in the first place. And they should have been able to, a company ought to have been able to say, well, if I know, now that I know that, I don't want to do business with the government. I think that's a reasonable result. So,
Thank you, Mr. Chair. Mr. Gimberling, do you have this document in front of you? Thank you.
Yeah.
And I've looked at this, and I'm a little perplexed, and I'm not an attorney, but I've looked at enough contracts and signed enough contracts in my lifetime to always look for the disclaimer or the absolution of defect clause.
Mm-hmm.
I don't find that in this, and I'm just wondering if I'm missing it, or is that a defect of this contract, and or as Representative Liebling provided it, is this specific to a specific provider, or can you give us any example in terms of your interpretation of why that type of a disclaimer absolution would not be party to this document?
Well, Representative Albright, I think that'd be a great question for the Commissioner of Health Human, or the Commissioner when they come up here. I don't know if you want to take a shot at it, Mr. Gabling, you're more than welcome to, but I think I'd like to hear the answer to that question come from the department itself.
Mr. Chairman, Representative Albright, I do know from previous experience that the Commissioner of Administration can delegate certain contractual authorities to other commissioners, okay? And I would be guessing, and it would be pure guess, that is part of what was done in this situation, and I think Representative Lesch is correct. You ought to hear from the parties in principle. And if that's the case, then if they've delegated that to Human Services, then Human Services produced what Representative Liebling has been kind enough to provide us. So, and whatever defects it may have are attendant to whoever drafted that at Human Services.
Any other questions or comments from members of the committee? Seeing none, thank you for your testimony, Mr. Gemmerling. We now have Catherine Commit, Minnesota Council of Health Plans. And it's the expectation of the chairs that we have Commissioner here in the audience. Well, okay, Ms. Commit, please introduce yourself and begin your testimony.
Thank you, Mr. Chairman and members of the Joint Committee. My name is Catherine Commit, and I represent the Minnesota Council of Health Plans. Thank you for convening this hearing. I appreciate the opportunity to testify on this important issue. I want to acknowledge that I did not testify when the bill was heard in the Civil Law Committee on March 5th. We were concerned about this legislation, but we were still studying the ramifications of this bill on our industry. My testimony will outline the current practice as it relates to this type of data for health plans and our primary concerns with the current language of House File 2167. I will also provide a relevant precedent that is already in law within Minnesota statutes. We believe this precedent should be the basis for creating an amendment that addresses our concerns. I will also discuss the consequences to both the state and the health plans if this bill is not amended. Let me begin with our primary concerns. Without changes to House File 2167, health plans would be required to disclose proprietary information such as confidential business information and subcontractor agreements with physicians, hospitals, and other vendors. House File 2167 changes the current practice of the Minnesota Department of Human Services, H.H.S, and potentially the practices of other state agencies. The health plans have viewed their contracts with the state as meeting the terms of the Data Practices Act under Minnesota Statutes 13.05, Subdivision 11. This view was recently upheld by the Minnesota Supreme Court in the case last November. In short, neither the health plans contracting with the state nor the state itself has viewed the terms and conditions of subcontracts between health plans and providers, hospitals, and other vendors as public information. This has been the understanding and practice for many years. House File 2167 brings to light an important public policy issue. That is, should the subcontracts of private parties contracting with the state be public? In the past, several governmental entities have interpreted the statute as giving them discretion to determine whether and the extent to which subcontracts would be public. For example, in the recent Minnesota Supreme Court case, Timber J Newspapers versus Johnson Controls, the school district did not include the requirements of Section 13.05, Subdivision 11, in its contract with Johnson Controls. DHS has also narrowed the extent of the language in its contracts with health plans. And maybe this would be the point to just read to you a paragraph from our DHS contract that we just looked up on an iPhone. It's this is available on on the DHS website. It's Section 13.3.3, part of the welfare system. And it says, the managed care organization, the health plan, will be considered part of the welfare system as defined in Minnesota Statutes Chapter 13.46, Subdivision 1, and agree to be bound by applicable state and federal laws governing the security and privacy of information. It doesn't say anything about the disclosure. So the language at issue is the notice provision in Section 13.05, Subdivision 11, which, if included in whole in a state government contract, would require a private person to be responsible for data as if it were a government entity. As written today, House File 2167 means that a private person would be responsible for not only maintaining the privacy and security of the data, which I just mentioned, which is not at issue here, but also for releasing the data, including data in the private person's subcontracts, if a request by an outside party is made. Mr. Anfinson, representing the Minnesota Newspaper Association, believes that DHS has not properly applied Section 13.05 to its contracts with the health plans. He has argued that the Minnesota Court of Appeals and the State Information Policy Analysis Division, IPAD, from the Department of Administration, have interpreted the statute as applying to virtually all government contracts, regardless of whether the mandated notice is actually included in a particular contract or not. However, the Minnesota Supreme Court, the supreme law of the state, has reversed the Court of Appeals determination and interpreted the law as giving discretion to state agencies to decide whether and the extent to which the notice provision should be included in government contracts. The state agency discretion is reflected in the contracts between the Department of Human Services and the health plans. In those contracts, DHS requires health plans to be bound by applicable state and federal laws governing the security and privacy of information, without also requiring that all data created, collected or maintained by a health plan be subject to all of the requirements of the Data Practices Act. In other words, without requiring a health plan to comply with the request for the release of data as if it were a government entity. This is the crux of our concern with House File 2167. A long-standing precedent to protect this information already exists. The legislature has previously recognized this exact concern. Chapter 62E is the Minnesota Comprehensive Health Association, or MCHA, the H.H.S statute, which governs the state's high-risk insurance pool. This statute includes a provision that protects this very type of data. Minnesota Statutes 62E.13 subdivision 11 provides that if the writing carrier, meaning the health plan, uses its own provider agreements for MCHA's provider network, then the terms and conditions of those agreements are non-public data. This particular provision was enacted back in 1991. There is also similar language in Minnesota Statute 62U, a statute that relates to the Minnesota Department of Health and healthcare reform. Yesterday, we met with Mr. Anfinson and representatives from the Department of Administration's IPAD division in an attempt to come to an agreement on amendment language. We appear to have agreement conceptually, and we have been trading language with Mr. Anfinson to memorialize our agreement. I believe we are very close to finalizing that language. I do have a copy of it, but I'm not going to distribute it because we don't have a final agreement on it. With this amendment, we are proposing language similar to the MCHA language, which would be included in the respective sections of law related to health plan contracts with the state. This includes sections in law pertaining to the State Medical Assistance Program, the Minnesota Care Program, the State Employee Group Insurance Plan, the Public Employee Insurance Program, and contracts that the health plans have with school districts, both fully insured and self-insured. For the following reasons, we believe it is not in the best interest of the state to make the health plan contracts with doctors and hospitals public. First, price transparency will drive up prices. The health plans are concerned that the disclosure of provider-specific pricing and contractual detail for the fees and pricing arrangements will result in higher health care prices for everyone. Today, each provider knows what his or her reimbursement rate is. If the rates are made public, there is no incentive for the providers to agree to a rate that is lower than the provider down the street. It will be a race to the top. Second, health plans are different. We are mandated to do business with the state. As a reminder to the members of the committee, health plans are required as a condition of state licensure to participate in state public health insurance programs. Unlike other industries that do business with the state, health plans do not have a choice whether or not to bid on contracts with the state. Since the early 1980s, the state of Minnesota has recognized the value that health plans bring through their volume purchasing of healthcare services and their business-driven cost containment efforts. The state of Minnesota benefits from these cost savings too. The state is able to depend on the sound business practices of the health plans to drive down the cost of healthcare for these state programs. Contracting with the health plans to provide these services ensures better coverage for enrollees than the state could ever negotiate on its own with individual providers. Third, unlike other contractors, health plans are at financial risk, not the state. Another important factor that differentiates health plans from most other contractors with the state is that the health plans are at financial risk for their contracts with the state. This means if the cost of the contract is higher than was originally negotiated, then the health plan is at total financial risk to absorb these additional costs, not the state. Making the health plans responsible for the full risk of these contracts provides budget stability and predictability for the state. Fourth, the health plan marketplace is already extremely competitive. As we've seen over the past year, competition works well in the private commercial health insurance market. In the last few years, DHS has moved to a competitive bidding model to drive down the cost of these health plan contracts even more. In fact, for fiscal year 2012, DHS reported they saved the state $175 million as a result of competitive bidding by the health plans for state public programs. Competitive bidding works because health plans compete fiercely against one another. They compete on price and added value. Therefore, it is necessary to maintain the confidentiality of subcontractor agreements to hold down the price and ensure value through innovative proprietary business practices. Fifth, health plans already provide a lot of information publicly. The contracts that health plans have with the state of Minnesota are public information. They are posted on the state's website. In fact, a great deal of information about how health plans perform as vendors for the state is available on the DHS website and the websites of the Minnesota Departments of Health and Commerce. These state agencies already have access to the health plan financial and quality data to ensure that the needs of state public program enrollees are being met. Sixth, we must recognize the negative impact this bill could have on the state's overall health care marketplace. The majority of Minnesotans get their health insurance through their employer or through a state public program like medical assistance or Minnesota Care. The cost of coverage is negotiated with providers by the health plan. Health plans are able to leverage a lower rate because they can assure a certain patient volume for the provider. Health plans can also negotiate payment arrangements as a means to incent more efficient and quality-driven providers. If enacted in its current form, House File 2167 will remove an important negotiating tool that health plans use to drive down the cost of coverage. If all of our negotiated rates are made public, we will lose much of our ability to negotiate lower prices. If the cost of coverage goes up, the cost will increase not only for the state budget, for DHS, and for CGIP, but the cost of coverage will also increase for Minnesota individuals and employers who purchase coverage in the private commercial market. So in summary, the health plans care strongly about this issue for one simple reason. If health plans are forced to disclose the terms of their negotiated contracts, the market will respond accordingly and the cost of care will increase. As a result, the rates paid to providers will increase for the state of Minnesota when purchasing coverage for enrollees in medical assistance, Minnesota Care, and CGIP, and may increase for individuals and employers who purchase coverage directly from the health plans. We believe this amendment is needed for House File 2167 to do two things: to classify as non-public data under Chapter 13 the terms and conditions of the contracts between health plans and providers and other vendors, and to clarify that nothing in this section of law requires the release of trade secret information. Thank you for the opportunity to testify, and I would be happy to answer any questions.
Thank you for your testimony, Ms. Commit. We do have several members who have questions. I have initially two questions for you, Ms. Commit. You had specifically stated the data sets that you're proposing to exclude from Chapter 13. There were 4 or 5 of them. Could you restate those?
Yes, Mr. Chairman. So what we are interested in doing is classifying in the following categories of statute. So the first one has to do with the state employee group insurance plan. That's the health insurance plan that covers all of you and state employees and their dependents.
So everything in the health plan?
I'm sorry, Mr. Chairman. No, what I'm saying is, here's how the language would read. If an insurance carrier authorized to provide coverage under the state employee group insurance plan uses its own provider and vendor agreements to provide covered services to eligible individuals under this section, then the terms and conditions of those agreements are non-public data as defined in Section 1302, Subdivision 9.
Okay. Maybe could you just state the other data sets you have proposed then, Ms. Commit?
Sure. The next one would be under the State Public Employee Insurance Program, the PEEP program. The next one is in Chapter 256B.69, which is the State Prepaid Medical Assistance Program. The next one is in Chapter 256L, which is the Minnesota CARE Program. The next one is in Chapter 471.6161, which deals with self-insured school districts and other local governments. And then the last one is in Chapter 471.617, which is the is also for school districts that are fully insured and other municipalities. And so this language would read pretty, it would be pretty parallel to what I just said, that it would just be specific to our own provider and vendor agreements, the terms and conditions of which those agreements would be non-public as defined under Section 1302.
Okay, thank you, Ms. Commit. So just one comment on that, that normally the Civil Law Committee would outsource the consideration of requests of exclusions under the Data Practices Act, Chapter 13, to the Data Practices Subcommittee. Just consideration of these provisions would, maybe you could do a separate hearing on each one of these proposed data sets. I think it's safe to say there's just a lot to talk about, the reasons for why you would request it to be non-public. And it's pretty late in the session to consider that, I think, but we'll see what members here think. But my second question, Ms. Commit, is that you had stated that it was your understanding that you had discretion of what to release as public data as part of your contract from 1999 through the November 20th court decision. Is that correct?
Mr. Chairman, members of the committees, I don't think that's quite accurate. I don't believe I said that we had discretion. I believe I said that there was discretion that the state agency, in this case the Department of Human Services, used some discretion to determine the terms and conditions of our contract, the contract that we had with them.
Okay, thank you, Ms. Commit. So upon whose opinion did you rely for the validity of that statement, that there was discretion? And it may be commissioner, it may be their legal counsel. Do you have a name?
Mr. Chairman, I don't know. I did bring an attorney with me who might be able to answer that question, who works in this area.
Okay, well, if someone has a name of who was asserting the discretionary clause, that would be, I mean, I guess that's what I'd want to know.
And Mr. Chairman, let me just, just so that the committee members understand what kind of a process this is, it's not really just one person from a health plan going over to the DHS offices and meeting with one person over there, like their general counsel or something. It's a multi-month, multi-person event that goes on for weeks and weeks and weeks to negotiate the terms of the contract. And it's a very intensive process. We at the council are not privy to any of that information because it's all being handled at an individual level with each individual health plan. But the possibility exists that each health plan could have different requirements in their contracts.
Thank you. Please introduce yourself to the record if you can address the question.
My name is Mr. Chair. My name is Ms. Mary Prutnix, and I'm with Medica Health Plans. I'm Senior Director, Associate General Counsel. I work in the legal department. I support government programs.
Thank you, Ms. Prutnix. Do you have a name of a person at the state upon who you relied for that understanding of discretion?
No, I do not, Mr. Chair. The discretion is really by implication in the statute, in our DHS contract. Our DHS contracts, as Catherine stated earlier, say that we're part of the welfare system, but it also says that we're part of the welfare system for purposes of protecting the privacy and security of information. It doesn't say anything about having to release the information or that we are required to comply with every aspect of the Data Privacy Act.
Thank you, Ms. Prutnix, for that opinion. What I'm looking for right now is what I had asked for is the name of someone. So let me ask my final question, because we do have quite a list here from folks. If in fact, Ms. Commit, it's your understanding, though, that you did not have to, prior to the court decision, you did not have to release the contents of this data in your subcontracts. Is that right?
Mr. Chairman, I am not an attorney, so I don't really know what the thinking was prior to the court case. I think that generally speaking, it was the practice that we followed the contract. The health plans followed the contract that they signed with the Department of Human Services, and that's what they followed.
Okay, so Ms. Kmit, is it possible then, in your opinion, that the law was being broken during the time between 1999 and the court decision of November 20th?
Mr. Chair, to that point,
Representative Portman?
The summary that Mr. Gehring gave us of the Supreme Court decision is that the Supreme Court of the state of Minnesota found that if these terms weren't in the contract, then people did not need to disclose this information. So to the extent there was discretion, I don't think this is a DHS issue. I mean, clearly in this case, it was a school district up in northern Minnesota. So any government entity had the discretion to not have this data disclosed by not including this language in the contract. So we're here today dealing with a specific DHS issue. And we could go down the path of who at DHS made the decision to put this clause or not put this clause into the contract. But what I think the health plans are saying is the way that they've been dealing with data and this issue is the same way the Minnesota Supreme Court interpreted was the law of the state of Minnesota. So, I mean, I get a little nervous when we use words like illegal and, were you doing something illegal and who gave you the advice to do something illegal when what they were doing was interpreting the law the same way the Supreme Court of Minnesota interpreted it, which we're now talking about should we change. So that's just the point I wanted to raise, Mr. Chair.
Thank you for that point, Representative Portman. Ms. Kmit, what is your objection to the language as proposed in House File 2167 if in fact it is stating that contracts must reflect the existing language interpreted by the Supreme Court in the decision?
Mr. Chairman and members of the committee, what the bill is doing, it's amending that particular statute and making it abundantly clear that whether the notice is included in a contract or not, the notice still applies. Again, that was not the practice that we were operating under previously under our contracts with DHS. Therefore, and this took a long time for us to figure all of this out. Therefore, that's why this bill has shone light on this issue. And as a result, that's why we are coming forward with an amendment to make sure that every place where the health plans intersect with a state contract, that the information about our contracts with providers and vendors and other subcontractors is classified as non-public.
Okay, well, Ms. Kmit, I'm genuinely trying to understand this for my own purpose because I have not been able to, honestly, in the 3 weeks that's been discussed. So I understand there's no objection to the understanding that any direct contract between a government agency and a health plan would be public. The question lies with the subcontracts or vendor contracts themselves. Is that a fair statement?
Mr. Chairman and members of the committee, I think that as we read the proposed legislation, we read it to mean that it'll address exactly what Mr. Anfinson was talking about when he argued the Timber J case, and specifically that Johnson Controls made the contract with the school district. Then Johnson Controls had a subcontract with other vendors, the electrical people and the plumbing, et cetera. The newspaper up there wanted to get a hold of what those subcontracts were. But because the school district had not put in their contract with Johnson Controls a provision or a notice saying it was subject to a Chapter 13, the Supreme Court said it didn't apply. Now, what we're dealing with is this legislation that is going to make it abundantly clear that that will apply both to the regular contracts and subcontracts. Therefore, we want some protection for our subcontracts, the data included in our subcontracts to be kept non-public.
But Ms. Commit, this is why I'm asking the question. The proposed language proposed in House File 2167 doesn't say anything about a subcontract. It merely says a notice that the requirements of this subdivision apply to the contract. Therefore, it would simply assert that the notice, as you stated, is eminently clear for the law, which was effective prior to November 20th and is effective after November 20th. So I guess I was hoping that through the process of this hearing I would get a better understanding of where the objection from the health plans lie in this, but I'm not seeing it. So, Mary, Ms. Pretnix, do you have a response to that?
Well, sure, Mr. Chair. This legislation would require that notice, regardless of whether or not it's included in the contract, that this requirement would apply. And it would also require that we would have to comply with all the requirements of the government data practices as a government entity, regardless of whether or not the Department of Human Services were to put a provision in our contract requiring that. Up to this point in time, and as the Minnesota Supreme Court acknowledged, state agencies have only been required or have been allowed to have discretion to determine the extent to which they would put the notice provision in the agreement. So they could determine whether it would go in and the extent to which it would go in. Currently, in the DHS contract, there is a provision. We do stand in the shoes of a welfare agency, but it's clear that it's for purposes of protecting the privacy and security of member information. And that's what we've been operating up until this point in time. And the Supreme Court acknowledged that and agreed with that interpretation of the law.
Okay, so Ms. Pretnick, well, tell you what, maybe someone else can answer some questions that would do better. There were some to this point initially, so I'm going to skip ahead. Representative Holberg, was that to this point?
Well, thank you, Mr. Chair. And I think maybe we can get moving in some way or shape or form here is, so as I listen to your testimony, what you're saying is that because the contract that you held with the state was silent on the dissemination issue of disseminating information, that you had no duty to disclose or disseminate any information to anyone. Is that correct?
Ms. Pretnick?
Mr. Chair, Ms. Representative, yes, that is correct. According to the Supreme Court of Minnesota, that's correct.
Representative Holberg?
Mr. Chair, I'm not sure that I would tie it to the court case because I think I'm on Anfinson's camp on the court case. I don't believe that the commissioner had the authority to exempt contracts from Chapter 13, whether it was in writing or not. And so, excuse me. So, I think this is a point where we're probably not going to come to an agreement. So that maybe at some point we'll hear from the department and that might shed some light. But as I have worked through this and when I listen to the testimony very carefully, I am pretty convinced that the things that you're worried about are trade secret information. And so your statement that if this bill becomes law that you will have to disclose all your contracts with your vendors and your providers, and looking at the definition of trade secrets, I would maybe argue with that statement. And so help us understand why the current protections under Chapter 13, in your opinion, are not sufficient to protect those portions of the contracts related to costs, et cetera.
Ms. Pretnick?
Yeah, Mr. Chair and Representative, we do also have another provision in our amendment that would protect the information as trade secret. We felt that that was necessary as well. And the reason being that if we are standing in the shoes of the government, a government entity doesn't have trade secret information. For example, our contracts with DHS does not have trade secret protection. Our contracts with DHS, after they are signed, all of the pricing information is made public. Therefore, we're concerned that if we're standing in the shoes of the government agency and somebody comes to us for information, we would need additional protection to ensure that that information would not have to be disclosed.
Well, Mr. Chair, I can tell from people's faces here there's probably going to be about 22 people waiting in line to get on the Data Practices Commission, but Anyway, that's just a side note, but I just am convinced that we need to determine what data sets they're most concerned about and give the classification and address it that way, that rather than when you give blanket exceptions, it's everything in the subcontractors and vendors' contracts is shielded, and I'm very uncomfortable with that approach.
Mr. Chair, and
One moment. Did you have a, well, we're just going to move on. Did you have any other questions, Representative Holton?
Well, Mr. Chair, I hope at some point we hear from the department.
Okay. I'm looking forward to that eagerly. So we have, to this point, Representative Scott, and then after Representative Scott, I have Representative Gruenhagen, Quam, Schoen, Albright, Clark Johnson, Morgan, Loeffler.
Oh, thank you, Mr. Chair. Most of what I was going to get at has already been said, but I just want to reiterate that I don't think, well, and I guess I'll wait for the testimony from the department, because I just don't think that there's any, discretion given on whether or not you adhere to a law that's on the books or not. And I don't have a problem with some comfort language, but another point that I would like to make is that I think that this issue did exist prior to this court case, and I think that it's been there for a long time, and it's just, whether you were living under a false premise or whatever, the law should be the law, and it should have applied. So that's my only comment, I guess.
Thank you, Representative Scott. So, members, I would ask, so the department, presumably, hopefully the commissioner, who's the one who's accountable, will come up and speak to this. But if you have a question of the individual representatives I just asked, if you have a question that can wait until after the commissioner has testified, that would be most helpful. But is there anyone on this list who wants to ask a question of Ms. Kmitt or Ms. Pretnix? I'll ask in order. If you can wait until after the department testifies, then please do so. Representative Gruenhagen.
Yeah, I'll just make some statements here. Thank you, Mr. Chair. And you can just shake your head yes or no. But, one of the things you saved $175 million on those are negotiated contracts. And Representative Lesch, that's why the Tylenol are $40, probably go to $80 next year. Okay. What they say there has to come out from somewhere. Admin and trial lawyers, and you see why the prices are where they're at. But be that as it may, is there any way to get a copy of your testimony? I always find your testimony to be very informative and understandable for a layperson, so unless it's covered by data practices, I don't know. But
I did bring copies of my testimony for members of the committee.
Oh, well, excellent. And the last comment is, and this is a bone of contention, I got involved with this issue as far as the health plans and the payment and knowing what, where, and I understand why you need some privacy there, or it's going to cause higher costs. But the one statement you made is that the health plans will be at risk if they lose money on administering these state health plans, the welfare programs. And there's strong opinion the other way that the state has to make you whole if you lose money on these programs. So the idea of risk is really eliminated if the state has to make you whole. And I had a copy of the state statute which kind of suggested that a couple of years ago. I don't have it here. But in your opinion, if a health plan loses money, does the state have to make them whole or not?
Mr. Chairman and members of the committee, in my opinion, if the health plan loses money, it is not the responsibility of the state to make them whole. They worked that out in the contract and said, the health plan says, okay, for this amount of money, we think we can provide health insurance coverage to this many individuals at, for this price, and we can manage it as best as possible to stretch those dollars and cover the costs. Sometimes that works, but sometimes it doesn't. I had one plan lose $53 million last year. It does happen. The health plans are also very good at what they do. They are very creative. They're fierce competitors, and they work very hard to try to push the envelope and find ways to make the healthcare system be more efficient and more cost effective for the state. And let me say one more thing. a long time ago, before managed care was used by the state of Minnesota to cover people on state public programs, there would be people who couldn't find a doctor low-income people who couldn't find a doctor to deliver a baby and that sort of thing, or felt discriminated somehow. Plus, the state would appropriate X amount of dollars to cover the cost of the Medicaid program, but they might run out of that money by September or something like that. By working with the health plans, they get two important things. One, they get access, the enrollees get access to all of the providers in the health plan networks. There's no discrimination. They can go to any provider within the network. But secondly, it assures budget predictability and stability for the state of Minnesota. The state of Minnesota doesn't have to come back into a special session to try and appropriate more money because the state Medicaid program is going to go broke.
And one final point, thank you, Mr. Chair. Just one final point of clarification is, so basically you want that information protected so that you can continue to negotiate in a way that gives the state the best bang for the dollar for the coverage being provided. Yes or no?
Mr. Chairman, yes.
Okay.
To that point, Representative Albright.
Ms. Kmet, I've asked this of other people, and I just want to, so your testimony to this point leads me to believe that you would be concerned that the bill before us or the information before us would be retrospective as well as prospective. Is that correct?
Ms. Kmet.
Mr. Chairman and Representative Albright, I guess the answer is I don't know. I think that we would want to work on the effective date of this, and ideally it should probably read for contracts issued or entered into and renewed after January 1, because our contracts go up until December 31st, our state contracts for the DHS programs.
Just a quick follow-up to that, Chair. So to the extent that there is vulnerability on the part of the state for litigation retrospectively, where is settlement for those claims that will be brought for contracts prior to the effective date?
Ms. Kmet.
No, Mr. Chairman, I don't think I can answer that question. I don't know.
Representative Loeffler.
Thank you, Mr. Chair, and this is an issue that doesn't relate to the DHS contracts. I wanted to ask it while they're here, but the model that Ms. Kmet that you had suggested we look at is based on MCHA, which gave you a specific exemption. And to me, MCHA, the Minnesota Comprehensive Health Association, created over 40 years ago, so probably no one in this room was there. But my understanding was it was a suggestion of the marketplace to solve the problem of people with pre-existing conditions being rejected by all private insurers. And I'm suspecting that at that time, the legislature considered something like we have now enacted into federal law, which is you cannot discriminate based on pre-existing conditions in setting rates or being willing to offer a policy. And that instead the insurance industry offered up a market-based proposal of collecting assets off of insurance policies, pooling that, and as an industry-controlled board, dispersing that. And so to me, that is a very different model, and I would question whether that was a government function different than the provision of medical assistance, which to me is a government function. And so could you address why you think the MCHA model would be a model for a government function in approaching this?
Mr. Chairman and Representative Loeffler, the reason the language in the MCHA statute, it's not the whole MCHA program we're talking about. It's a very specific, narrow provision that relates to protecting certain information as non-public. And the reason it's relevant here is because the legislature already anticipated this and contemplated this problem, and in fact, put it into statute back in 1999. It recognized that it was important to keep the subcontracts between the health plan and their providers and other vendors and subcontractors private or as non-public data. So I'm just saying that a precedent exists already. It was contemplated by the legislature many, many years ago and enacted, and I would say that that's worked very well. So I think that because there already is language in statute, it's prudent to try to make the other parts of the statute, the other government, everywhere we intersect with the state for a public program, to make that language parallel to the way it was in the H.H.S statute.
Mr. Chair, I know we need to move on. I would just note for the record that she didn't respond to the question I raised, which is whether or not that was seen as a different program than a governmental function.
Duly noted, Representative Loeffler. Thank you. We've got Representative Huntley.
MSHA was paid for by taxes that the state raised, so that was a government function.
So on the list, and if you can hold off until after the commissioner has testified, Representative Quam, Representative Schoen, Representative Clark Johnson, Representative Morgan. Anyone have a question specifically for these folks that can't wait until after? Representative Clark Johnson.
Thank you, Mr. Chair. I just a lot of your cases based on pricing, and I just want to raise a couple of questions about your assumptions. One is it seems to be goes counter to the free market, whereby you talk about if there is no knowledge of prices, that prices are lower, that if there is knowledge of prices, that there would be a race to the top. It seems to me that when there is competition in pricing in the marketplace, that there tends to be the assumption is that there's a race towards a lower price. Can you explain to me why you assume there'd be a race to the top?
Sure, Mr. Chairman and Representative Clark.
Johnson.
I'm sorry, Representative Johnson, I apologize.
That's okay.
This is a really big question, and it has to do with how healthcare economics works. And I'm not an economist, but it works a little bit differently than in a traditional, vanilla marketplace where you have supply and demand and willing buyers and sellers who are participating in that marketplace. In this marketplace, we don't have we as individuals are the consumers of health care, but we don't individually, very few of us anyway, individually purchase health care. But when an individual does purchase health care, that information is very much public. If you went on the MNsure website or you go to any of the health plan websites, you can put in information and figure out exactly what your cost is going to be covered. What you're not necessarily going to find out is, well, how much does the health plan, what kind of a contract, what kind of contractual arrangements does the health plan have with a big hospital system or a clinic? Now, individual providers might be interested in knowing that information about what everybody is getting paid, because there is going to be differences across the state as to how much individual providers are reimbursed through our contracts. And part of that is because there's different supply and demand. We have a dearth of child psychiatrists here in the state of Minnesota. So the very few child psychiatrists that we do have, we want them to be in our network. We want them to be credentialed and, have kept up their licenses and do all those things. But if we can, we would like them to be in our networks because there just aren't enough of them. So when we do have a child psychiatrist or another type of provider, for example, we will probably pay that provider more than what, somebody else might get paid. That information is known to the individual provider. What's not known to the provider is how much the provider down the street is getting paid, or in the next county, or in the other part of the state. If everybody knows what they're being paid, I can bet you that the people who are getting paid or reimbursed at a lower rate are going to say, I want to get paid what you're getting paid. And I think that that's the conundrum we face.
Okay.
Mr. Chair.
Representative Clark Johnson, do you have a follow-up to that?
I have a follow-up to that, and I have a second question. I would argue that based on the experience.
So let me just ask, Representative Quam, Representative Schoen, Representative Morgan, do you have questions specifically for the testifiers that are up there now? You don't?
My question's been addressed.
It has, okay, thank you. Representative Quam?
I'll be further enlightened by the next testifier.
Okay. Representative Schoen?
I've got questions that can wait, and I can find out who can answer them.
Okay, thank you. Okay, so Representative Clark Johnson, go ahead.
Okay, thank you. And I know, but nonetheless, this case is being made on pricing. I would argue that a case specifically with the tiers in Mankato this year would suggest the opposite of that. And I just want that for the record. The second question, you assert that contracting with the health plans provide these services ensures better coverage for enrollees than the state could ever negotiate it on its own with individual providers. Given the experience with other countries that do negotiate directly with providers, how is that inherently true?
Ms. Commit.
Mr. Chairman and Representative, well, there are thousands and thousands of providers, and if we want to move to a system here in Minnesota that is a single payer or where the government is negotiating all of the payment rates with individual providers, that's certainly something that the legislature could decide to do. I think that you would hear from some more people, probably providers, who would not be in favor of that kind of market. You know, for good or for ill, the kind of system we have here in the United States is an employer-based system. It's not perfect by any means. But we think that we do a much better job here in Minnesota. We think that the health plans are local, they're nonprofit, they're very much mission-driven, and they work very hard on behalf of their enrollees to negotiate contracts with providers and hospitals and other vendors that are the very best. It's not in our best interest to have a very expensive product that people can't afford to buy. One of our missions as the Council of Health Plans is to make sure that every individual, every person in the state of Minnesota has coverage. We support universal coverage because we're all better off when everybody has coverage. But your question about, well, how could other countries do it better? They do it differently. That's true. And there isn't the negotiation then happens between the government and the individual providers. And that's something that the legislature could look at.
Thank you for your testimony, Ms. Commit. And I have one final question that maybe can, and again, I'm having a little bit of trouble understanding this. So before you leave, could you state that if you're sure that the law 1305 subdivision 11 did not apply to you with respect to the disclosure dissemination of this data, why do you need an exception with the data sets that you had proposed?
Mr. Chairman, I'm going to say something that I'm going to turn it over to Ms. Pratt next to give a more thoughtful legal answer. But I can assure you that we have been told by various parties that the minute this bill becomes enacted, there will be a mountain of requests for our data on all of our subcontractors and with contracted amounts for our providers, our vendors, and all the subcontractors. We know this is coming because this bill, the case, I suppose, and then the bill shed a lot of light on this issue that previously had not been understood. But I can assure you, I've been told that everybody is interested in knowing how much we pay providers and our other contractors. So I'm going to let
Thank you, Ms. Commit. But I would just note this, okay? For those of us on the committee that deal with Chapter 13 or data privacy issues, I would just make clear that every single entity, person, or group comes up here and asks for an exception to the presumptively public nature of data under Chapter 13 states pretty much the same thing. They say if you don't make our data private, if you don't hide our data from the taxpayers, your healthcare costs are going to go up, your gasoline prices are going to go up, your taxes are going to go up. And it ends up being kind of a legislative boogeyman. And so I understand that that's your perspective and that's your pitch. But because that's what we routinely hear, we really need to take a scalpel of this, for pardon the healthcare analogy, and sift down to what we're really, really talking about as to the specific reasons for the request for the exceptions on the data sets. But with that said, Ms. Prednick.
Mr. Chair, first of all, I'd like to make a clarification. You've asked, a number of people have asked about the Department of Human Services and whether or not they believe that that they're in compliance with the law or not. I cannot speak on behalf of the Department of Human Services. When I'm speaking on historical knowledge and understanding. And in the past, this has not been an issue for us. We have not had anyone coming to the health plans asking for our data with our subcontractors. This just hasn't been an issue in the past. However, as Catherine mentioned, now this has been brought to light that this is an issue, and potentially because of this legislation that was brought forward, we looked at it, we thought this does apply to us, and so now we do have a concern about it moving forward. We do believe that based on the way that and this is the health plan's belief, this is not the Department of Human Services belief necessarily, but we do believe that based on the way that the contract language is drafted, it looks as though the department was requiring us to stand in the shoes of a welfare agency for purposes of maintaining the privacy and the security of the data, not for purposes of disclosing the data to anybody who comes and requests it. In other words, making a FOIA request of us as a private entity. And that brings me to my next comment in that the Government Data Practices Act is supposed to protect government data. It's not supposed to be there to necessarily protect data between private individuals and proprietary business information between private individuals. And that's over what this legislation, what the IPAD and what the Court of Appeals, I think that in their determinations, from our perspective, we never understood that was their understanding or interpretation of the law because, quite frankly, it just never came before us before. However, now that the Minnesota Supreme Court has held that it only applies, this language only applies if a provision, the notice provision, is in the contract, we wholeheartedly agree with that, and we think that the Supreme Court had it right, and that all along the state agencies, a number of different state agencies or governmental entities, agreed and believed that the language only applied to the extent to which it was included in a contract or whether or not it was included at all. So our concern about this language is that now this language is going to apply. If our amendment doesn't get on, this language will apply to our private, proprietary business agreements, something not contemplated by the Government Data Practices Act. This language will apply to those contracts regardless of whether or not the language is put in our agreement.
Okay, so, and again, it may be a little slow today, Ms. Brennick. It's been a long week. But if you agree with the Supreme Court's interpretation that it only applies if that language is in the contract and it doesn't mandate that the language be in a contract, then you're okay. Why do you need exceptions for separate data sets as mentioned? CGIP, PEEP, 256B, 69, 256L. Why do you need specific exceptions for all those?
Mr. Chair, because with this legislation, with the legislative language being brought forward by Mr. Amundsen, it will apply regardless. Additionally, our understanding is, and we were told this yesterday by the Department of Administration, they are going around and talking to state agencies and telling them to ensure that everybody puts this language in our agreements and that we can expect this in our DHS contract next January 2015.
Well,
so now we've kind of even gone beyond the former interpretation and moving forward since we were under the assumption that this was moving forward, that this was going to pass, and to the extent it is, we want to ensure that we're adequately protected, and all that we're asking is for an exemption consistent with that which has been in law for another governmental program since 1991.
Okay, well, I would just note, Ms. Prednick, that the extensive nature of the exemptions that you're requesting, as stated in Ms. Committ's testimony, typically require far more than even a single legislative session to digest between multiple committees and expertise areas, and probably actually more than one legislative session. So bringing it forward a couple weeks before the end of session, or 3 weeks, even a month, is typically inadequate.
Mr. Chair, and just to that point, and why I think this is why we heard testimony from admin that they are now instructing all of their departments to put the language in their contracts. So your problem is not related to his bill. Whether his bill passes or not, given the general understanding by legislators and everybody else that law applied to everybody, and the surprise Supreme Court decision that said if it wasn't contained in the contract, it didn't apply. You just heard testimony today that they're working on putting this language in every single contract. So irregardless of what happens with Representative Lesch's bill, in your next round of contracts, if what Ms. Byer-Kopinski said is correct, you will be looking at having Chapter 13 apply and you being government entities by virtue of the contract.
Mr. Chairman,
Thank
one
you
more
very
thing.
much. Okay, parting comments, and then we're going to go to the Commissioner. Go ahead, Ms.
I would just say, just to maybe make it more understandable, when a health plan contracts with a group of providers or a hospital system, they don't contract just for the commercial population is over here, and then the Medicaid population is over here, and state employees are over here. They contract for the entire volume of patients who are going to flow through that provider system. So the reason why we're very concerned about this is that if we now have to disclose all the information about our subcontractors, it's not going to affect. It's not just about the data related to the programs for CGIP and the Medicaid program. It's our contracts for our entire populations, and that has a huge impact on the cost of health care.
Thank you. Thank you for your testimony. Is Commissioner of Health and Human Services here? Okay, I don't sit on those committees. I don't even know what the Human Services Commissioner. I've survived 12 years without having to sit on that, so I'm not going to start now. So, hello, please introduce yourself for the record.
Good afternoon, Mr. Chair and members. My name is Amy Akbai, and I'm General Counsel for the Department of Human Services.
I'm sorry, would you state your name again?
Amy Akbai, A-K-B-A-Y, and I'm General Counsel for the Department of Human Services. And Commissioner Jessen apologizes for not being able to be here today. She is on the road and has instead sent myself and Mr. Golden, who will introduce himself in her place.
Mr. Chair and committee members, Jim Golden. I'm the Medicaid Director for Minnesota.
Okay, thank you. Please begin your testimony. Who's going to talk first?
Thank you, Mr. Chair. Our purpose for being here today is basically to let the members and your committee know that the department does not take a formal position on the bill.
Hey, could you pull the mic up a little bit too? So department does not have a position on the bill. Is that right, Ms. Akbai?
Mr. Chair, that's correct.
Thank you. That's all you're going to say?
To the extent that we can, Mr. Chair, to the extent that we can address the committee's questions, we're happy to do so.
Okay, Representative Holberg.
Thank you, Mr. Chair. Mr. Goldman, it's my understanding that in past years you were like the administrator in charge of doing these contracts with the health providers. Is that correct?
Mr. Golden?
Mr. Chair, Representative Holberg, yes, I had a lot of responsibility and still do as it relates to the contracts, both with our providers for our fee-for-service program as well as our managed care contracts.
And Mr. Chair, I watched you today. You were here most of the hearings, so you've been listening to all this fun that we've been having for the last couple hours. Can you explain to us your thoughts about this data dissemination issue and the belief on the part of the health plans that they weren't subject to those components of Chapter 13 or the Subdivision 11 that we've all been talking about? Do you agree with their assessment? Does the department have a position on this?
Mr. Golden?
Mr. Chair, perhaps I may explain?
Go ahead, Ms. Akbai.
Okay, thank you, Mr. Chair and Representative. So without giving a formal position, I'd like to just explain where the department might be with respect to that. We have deferred, as we've been looking at the language of this bill, we've deferred to the Department of Administration on their interpretation of how the law had existed in the past and now how it has not substantively changed going forward. There's been various advisory opinions, and then we have the Court of Appeals decision recently. And so we have deferred to the Department of Administration's position on that.
Representative Holberg?
Well, Mr. Chair, I don't really care about the Department of Administration's position on this. What I'm trying to figure out is when these contracts were executed and you have people that work in these health plans and executive offices with big lawyers that get paid a bunch of money, and they're signing contracts with you, and you're having discussions and implementing these things. We heard their testimony today at the table saying that they believe by virtue of the contract that they were, as far as related to dissemination of information, that they were not subject to Chapter 13, but only to the terms of the contract and Chapter 13 as it related to storage and privacy. And so when you were executing these contracts, why was Subdivision 11 never referenced, and what was the department's position on dissemination of the information?
Ms. Akbe.
Mr. Chair, Representative Holberg, our current read of the law is that it basically hasn't substantively changed, that this is what is required, the notice requirement under current law, that is a notice provision that exists and has existed. And I can't speak for every contract or every point in time for which we executed contracts, what the thought of the agency was at that time. But under a read of the law, the current read and the read as it has existed is this applies and it should be inferred.
Representative Holberg.
It looks like maybe Mr. Gold wants to weigh in, because once again, I'm not getting a straight answer.
Mr. Golden.
Mr. Chair and Representative Holberg, I would say with regard to the contract that we do with the managed care organizations, they are subject to 13.46 explicitly in the language. It also requires them to be bound by applicable state and federal laws governing security and privacy. With regard to 13.46, which is the welfare data, that portion of Chapter 13 has provisions for both data on individuals as well as data not on individuals, and has all of the data. So it has all of the requirements related to use, maintenance, collection, and dissemination consistent with Chapter 13. I would also say that there are other parts of statute that have a variety of applicability to what health plans can and can't release. The Minnesota Health Records Act, for example, as well as others that would be in other parts of statute.
Ms. Akbe, I have a question for you. And help me understand, because I don't practice this area of law. But let's say the green lawn guy with his big tank truck comes by to spray chemicals on my lawn. And by law, that guy is supposed to supply me with material safety data sheet of what goes on the lawn. I think it's federal law, state law, whatever. But in the contract, I sign with the green lawn guy. It doesn't have that provision. My understanding is that the Supreme Court stated that, well, he didn't write it in the contract. That provision of law doesn't really exist, and it doesn't hold true for the contract. And he's not obligated whatsoever to supply me with the contents of whatever goes on my lawn. Am I incorrect in interpreting the decision like that?
Mr. Chair, a contract cannot go and undo state or federal law.
Okay, so I'll take that as a yes. So can you explain to me, and again, I read the decision, but I didn't get it in there, how the Minnesota Supreme Court was able to make that extrapolation. Could you synthesize that for the committee?
Mr. Chair.
And then the answer no is quite all right also.
I prefer not to. I tend to disagree with our Supreme Court, and I'm sorry I'm getting this on the record, but it
we'll destroy the tape after.
Okay, thank you. Thank you.
Thank you. Okay, I don't have any other. Are there any other questions for Mr. Golden or Ms. Akbe? Representative Albright.
Thank you, Mr. Chair. Ms. Akbe, as it would pertain to the Minnesota insurance marketplace, which is now law, in several provisions it does require that participants to that are subject to Section 13. Is that your understanding as well?
Ms. Zuckman?
Okay, Mr. Chair and Representative, I believe that's in 62V under the MNsure statute.
Yeah. Okay. Mr. Chair.
Representative Albright?
Thank you, Mr. Chair. And to the extent then for contracting with various providers to that body of law, Section 13 would apply, would it not?
Ms. Zuckman?
Mr. Chair and Representative, I don't feel comfortable answering that question without looking fully at the law.
Mr. Chair, would the DHS Commissioner answer my question?
The Assistant Commissioner, Mr. Golden?
Assistant Commissioner.
Do you have an answer to that?
Mr. Chair, I don't have any answer to that other than MNsure in Chapter 62V is subject to Chapter 13. How that exactly applies to their situation would be better for that organization.
Representative Albright?
Mr. Chair and to the Assistant Commissioner, so is there an implication that discretion was used with enforcing the law that was passed last session?
Mr. Golden?
Mr. Chair and Representative, I'm not sure I understand the question, but that's a question that might be better directed toward MNsure and their general counsel.
Okay, well, did you want to rephrase or you want to?
Mr. Chair, thank you. Is it the Assistant Commissioner's understanding that the law in 62B, as it would also be pertinent to Section 13, applies to MNsure?
Mr. Golden?
Mr. Chair, I assume that it would, but I don't. That's not my area of expertise.
Mr. Albright?
Mr. Chair, if the Assistant Commissioner could then identify who would be the applicable party that would be authoritative on that matter.
Mr. Golden? Can I give a name or a position?
Mr. Chair, Representative, I believe it would be best to talk with the general counsel for MNsure, Mike Turpin.
Well, we don't. Mike Turpin's not here, is he?
Mike, of course.
Okay. Any other questions, Representative Albright?
No, thank you.
Okay. Representative Quam, followed by Representative Schoen, Representative Scott, Representative Lane.
Thank you, Mr. Chair, and the rest of the triumvirate of the three committees. This testimony and the interaction has caused me to feel as if two issue areas have ripened, and they cause concern with, this bill. The first area is with the implicit or inferred discretion or flexibility of an agency to ignore, or dare I say, not follow statute in whole or in part, to invent new definitions or clarifications of subsets of what data can be defined. And I'd like to find out from either one of the two testifiers, what assurances do we have that if there's been this discretion from statute, that this bill will actually be adhered to, or will there be further flexibility discretion by the agency when doing contracts with vendors?
So what do you think, Mr. Golden?
Mr. Chair, Representative Quam, I guess I would say that there has been a lot of discussion here today about the Department of Human Services exercising some discretion with regard to how data is classified. I'm not sure I've heard any specific example of that. To the best of my knowledge, we follow what is classified exactly in state and federal law. The only piece of discretion that is there is what is already in the law as it relates to whether or not something is trade secret. The contract with our managed care organizations allows them to attempt to justify that a particular piece of information is trade secret as it is defined in 13.37, and we would use that same process for anyone who makes such a claim. They're quite frequent, for example, on any kind of bidding that is done. Almost any vendor that responds to an RFP stamps every page with this is confidential or trade secret. That doesn't make it trade secret. That simply says before we release it, we have to give them the opportunity to justify, according to 13.37, that it is in fact trade secret. But beyond that, I'm unaware of anywhere where we have either tried to define something in our managed care contracts that wasn't already in law as public or some other data classification.
So would you state, is it fair to state, Mr. Golden, that Department of Human Services has, in every contract that it's ever written, complied with the provisions of 1305 subdivision 11? Ms. Akbe?
Mr. Chair, I think that's a tough question to answer, and I guess we would hope and argue that we have, but it's to be seen if we haven't, and we'd certainly, I mean, that's a really tough question to answer to sit here today, and I would certainly hope and argue that we have.
Okay, well, I mean, and I appreciate that answer, although I would state that if you had, I don't think we would have spent 2 hours talking to Ms. Commit and Ms. Pretnix, but because I'm sure they probably wouldn't care and would be spending their time the way normal people are on a Friday like this instead of in here. But that said, Representative Quam, did you have any other?
Yes, I did. Thank you, Mr. Chair, the other area. And thank you for astutely following the line of questioning that I was pursuing with the first issue. The second issue is the defining the speciality of, certain contractors, a subset of contractors or vendors. And it was touched upon that if you can't do business in the state, in your business, without doing a contract with the state, that would be a basis for classification. It'd be nice if the staff could let us know if there's the subset of that, set of contractors or vendors includes anyone outside of the healthcare industry, because then it'd be easier to, maybe get around that. And that's why I think it's ripe that we look at any special class. And I do consider it special if you're doing a building or Johnson Controls, which was in the case that we talked about, you can do business outside of government. But in the healthcare industry, frequently you have to have that contract with the state agency in order to pursue. So I'd like to find out if there are any other examples, and then over the next session or two, we might be able to clear this up.
So, Representative Quam, who did you want? Was that a question, or who were you addressing that to?
Well, I was hoping that the staff, and we've got, I believe, staff from 3 areas, that they might be able to determine if there are any other entities which only can do business in the state if they have a contract with the state.
So is that right, if staff get with you offline with that question?
Mr. Chair, absolutely. I foresee this being 1 or more sessions in order to resolve.
Thank you, Representative Quam. Representative Schoen.
Thank you, Mr. Chair. This has been a heck of an education so far today. Civil law is interesting. I sit on the healthcare committee, and I realize we're combined, so I'm going to bring it back to a little bit of healthcare so maybe I can understand what the implications are into what we're talking about. So my questions are going to be about some notes that I took from everybody that was here today, and I apologize if this is a little mixed up. But and maybe Mr. Golden or Ms. Akbai, and I apologize if I said that wrong, can tell me, are the negotiated rates to the health maintenance organization plans for Medicaid available to the state? Maybe not publicly, but are they available to staff to be audited? And I will go further, because I heard Ms. Commit say that, a plan lost $50 million and they're obligated to provide the coverage. And then even further than that, I'm going to ask, has anybody ever come and said we don't want to provide or have to provide or contract with the state to provide medical assistance coverage? And can we tell from year to year what the profit margins are then? And that's why I want to know about the auditing, if the contracted rates to the subcontractors are available, so that you can tell well, this year we made $150 million, last year we made $25 million, we lost $50 million, and how do we track that? So that's a start.
Who's that, Mr. Gold?
Either one.
Mr. Gold, go ahead. Why don't you take a crack at it?
Mr. Chair and Representative Schoen, that's a lot of questions, but let me try to work through some of those because I think there's some different pieces. So first, with regard to the rates, the premium that essentially the state pays to the health plan, that is public information as soon as the contract is signed. Additionally, all of the assumptions and development of that capitation rate or premium is also public. We are required to tell the federal government through an actuarial memo as well as a certification checklist how it is we arrived at that rate. So that is publicly available. With regard to the health plans, a couple of other things that are publicly available. So every April 1st, all of the health plans and insurance companies are required to report their audited financial statements. They follow the national standards that are put out by the National Association of Insurance Commissioners in reporting that information. That does break down their general audited, their financials in a number of ways. Additionally, in Minnesota, they're required to file something that's called Supplement 1. The Supplement 1 also breaks it by product lines. So it would allow us to see what their revenue, their medical expenses, their admin expenses, and a variety of other things are by both our PMAP program, our Minnesota Care program, and various programs for our seniors that run through the plans. With regard to the other question that you were asking is, does the state get information that is more specific than what's in their audited financials? We do. Some of that would be public through our rate, the memo that our actuary makes public to show how we set the rates. So that would break the entire industry, for example, by the amount that is spent on hospital versus pharmaceuticals versus outpatient activities. Additionally, I think your question was, does the state, for its purposes, get more detailed data that is specific with regard to the providers that a health plan might be using? We do, as part of the encounter data that we collect on a biweekly basis. For every healthcare claim that comes to one of our health plans that they then pay, that information, both what was on the submitted claim as well as the paid amount, as well as the allowed amount, which would be the total amount that the provider would get, is submitted to the state. And that data is classified as not public data under Chapter 256B.
Thank you, Mr. Chair. And I think that I believe I heard some comfort there because I'm not trying to get to this line of questioning to villainize health plans or anybody. We talked about at the end of the session, towards the end of the session last year, I know we had some discussion about overpayments and how we arrived at making sure that, I mean, does anything in this law help make that more clear of is there overpayments or what the overpayments would be through Medicaid or, and that's kind of I mean, if you have, I just wanted to make sure that there is something in place, and it sounds like there is. I'm not necessarily concerned that that goes to everybody, but as long as our agencies are able to audit that. Is that accurate?
Mr. Gold?
Mr. Chair and Representative Schoen, that is accurate. I would say that I think that a lot of the concern that came up last session was around the total amount of payments that were paid to the health plans. The easiest way to be able to see where we are as a state on that issue is the April 1 filing. So for each of the plans, for each of the lines of business that they provide to the state, it is possible and quite easy to calculate what the operating margin, which is the amount of revenue above their cost that each plan made on each product line. And in fact, that is an analysis that both the Department of Human Services and the Department of Health routinely do and make publicly available.
Thank you. Thank you.
Okay. Representative Scott.
Thank you, Mr. Chair. And I'm not sure which testifier this questioning would go to. But if someone would have requested, say, a year ago, prior to this court decision, if someone would have come to the department and asked for a copy of a contract with Medica and anyone that they subcontract with, so maybe it's HCMC or maybe it's a private provider, and they would have asked for those contracts, what would have been your response? Would you have provided those contracts for them?
Mr. Chair and Representative Scott, yes, we would have provided that. In fact, the Medica contract is publicly available on our website. The 2014 contract is there now. You can also get previous year contracts. A little nuance to the question of anybody they might subcontract with. I think if what your question is, would we tell them which providers they were contracted with? Absolutely. That's actually part of our provider directory. That's something we absolutely want our enrollees to know. So that is also publicly available information because it's necessary for the enrollees to be able to choose a provider for to meet their needs. That is also available on request both to the public and to our enrollees.
Thank you, Mr. Chair. If that same person would have requested a contract with every child psychologist that Medica did business with, and those contracts would contain, what those providers are being paid per visit, would that have also been information you would have given?
Mr. Chair and Representative Scott, no, for two reasons. The first is that if the question is, name every child psychologist that Medica is contracted with for the purposes of our programs, that would be publicly available information, and we would share that. With regard to the contract, generally speaking, the Department of Human Services would not have access to the exact contract. This is not a routine piece of data that we collect from the organizations. And even if we had that information because we needed it for an analysis that we were doing, that particular information would be classified under 256B.69 as not public data. So we wouldn't have shared that. Additionally, I suspect in whatever reason we would have collected it, my suspicion is that the health plans would have informed us that that was trade secret. So in addition to the assessment of being classified as not public in statute, we would have gone through the process of determining whether or not it actually met the statutory criteria for trade secret.
Thank you, Mr. Chair.
Representative Lane.
Thank you, Mr. Chair, and I'm following along behind Representative Schoen here. One of the things, when you do contracts with the health plans, that is a government contract. There's no doubt about that. It's not, is it a government or not? And we do it to save money to make the contract. And anytime we do a contract with any entity from the government, we want to make sure that we're getting the bang for our buck. We want to make sure we got the value of our dollar. So we need to know whether or not we're actually getting a good deal and it is actually worth our time. That's why we call them demonstration projects for some of these things. And so you would need to have enough information back to know. And I think 1 year ago when we had the Siegel report, we had the results come straight from them who understand things across the whole nation with states contracting with insurance companies. And they clearly said that we're relying on self-reported summary data for a 10-year period, and that was unreasonable, that we didn't have paid encounter data that resulted in understanding what was exactly happening, giving us the information we need, that we weren't getting the data we need. We were relying on self-reported data. So my question actually would be, are we doing that? Are we actually giving them an easy ride? You said that they would attempt to justify if it's trade secrets, and we would give them a chance to justify if it's trade secrets. I'm beginning to feel like maybe we give them an easy ride on that, because if they didn't have trade secrets and it was data, information that we had available to us, would the problem be that then it would be public? Or would it fall under this 256.B? How come we're not getting this data? Are they getting an easy ride on trade secrets? Is it afraid it's going to be public? What?
Mr. Goldman.
Mr. Chair and Representative Lane, I just want to be clear, we are getting that data. So for each claim that a provider sends to a health plan, that is reported to DHS, and it does include both the amount that was paid from the health plan to the provider and any amount that the enrollee would be responsible for. That data is classified in statute in 256B. 0.69 as non-public data. So the state is getting that, and the state would get that whether it's trade secret or non-public because we're authorized by statute to collect it, and the health plans are required to give it to us. The import of it being either non-public data or trade secret data is really in our authority to release that to a data practices request. And so it doesn't, whether or not it's trade secret does not impact our ability to get that information. It impacts our ability to release the information.
Okay, good. The question would be then, are we doing it differently than the Siegel report disclosed, or are we doing it differently then at this point? Because they clearly said that for 10 years we had not been using that data to set our rates.
Mr. Chair and Representative Lane, that's correct. For the bulk of those 10 years, there was not statutory authority to collect that particular data, the claim level data for paid and allowed amounts. So for the bulk of the years that the Siegel report looked at, there was not statutory authority to collect it, and DHS did not collect it. The authority to collect that information, if I'm off the top of my head, I believe came in the 2010 or 2009 session. Our first collecting of that data began in 2011. And so we have been using it since then as part of the rate setting process.
I would just say that I will have to, I'd like to see more on that.
Representative Holberg.
Mr. Chair, I'll pass.
Representative Dean.
Thank you, Mr. Chair. Mr. Golden, if you could just, two quick questions. One is just the definition of trade secrets and how that is used by the department. And from a rudimentary understanding, if you have three competitors and one is awarded a contract, sharing the information from the award winner to the other two would be considered a trade secret that is protected to maintain a competitive environment. Is there ever a condition where we have only one bidder, and does that change whether or not that information would be considered protected?
Mr. Chair and Representative Dean, first I would say that the definition of trade secret is in Chapter 13.37, and it has 4 characteristics, and I'm sure if Mr. Gehring would be, he could explain it as well as I could. And basically we look to see that if whatever piece of information someone, whomever it is alleging to be trade secret, there's an analysis to see if it meets those 4 criteria. Normally the way it would work is someone alleges that it does. We ask for justification as to why that's the case. We look at it, and then we either say it does or it doesn't. If we say it doesn't, they have other remedies available to continue to try to protect that data. With regard to your other example, I just want to be clear, if we issue an RFP and we choose 3 vendors, as we would, for example, with our health plans, we have 8 health plans that serve our populations. All of their contracts are public information, and generally speaking, they're all provided the same rate or a bid rate depending on what their bids were. It wouldn't matter. We would make that public regardless of whether there's one or multiple vendors.
Mr. Chair.
Representative Dean.
And just to follow up on that, I've introduced a bill a few years ago that tried to look at this a little bit, and
threw it back in this year and have not, didn't get a hearing. But one of the things that has always kind of confused me is the actual costs after the contract is made. Whether or not that would constitute trade secrets or not is something that I question. That's why I kind of threw it in a bill to kind of think about it and talk about it. And also to see, just going forward, if you have ever had an instance where that has occurred, or if that has ever come up to your knowledge within the department, whether or not you know that or could get back to me on it.
Mr. Chair and Representative Dean, I have to be honest, I'm not aware of any case where we have done a contract that the information with regard to the contract itself, the payment, wouldn't be public. Only in some unusual circumstance, if it was part of an investigation where it was not public until such time as maybe an investigation was over or something like that. Certainly, I think just to be clear about some of the issues you've heard around the plans, all of our payment to the plans, all of our method for how DHS pays the plans, and how we do other adjustments to that is public information. And again, as I was telling Representative Schoen, all of how much the cost is in relation is public information, because that's reported annually to either the Department of Health or Department of Commerce for the people that are serving our populations. I think what's not public in this case is what the health plan's actual contracts with their contracted providers are. That's what, when it's in our hands, is classified as not public.
Mr. Chair, last question. I think that is the piece that I think I can show you my bill at some point, but that's what we're kind of looking for, some aggregatable data that we could look at. But the last question, Mr. Golden, is Ms. Commit had testified earlier that the plans are in effect on the hook for underpayment from federal payers for our programs. But in our supplemental finance bill, there is tracked $200 million from one year and 160-some million from the other year from the Healthcare Access Fund to the General Fund to supplement the underpayment of our basic health plan. How does that square, and how are you seeing that from a policy level working out with our other programs?
Representative Dean. So I'm not a health policy guy, so some of this stuff I don't track, but can you tell me, is it your intent to discern based on that question? Maybe you can explain how it would apply to House Bill 2167. I'd help better understand that.
Well, actually, I was sitting over there next to the other Representative Dean, and I just thought of the question, and I don't normally get a chance to ask a commissioner or assistant commissioner a question, so I had it, so I took it. So if you want to control that, that's your prerogative. But I am very interested in the use of the Healthcare Access Fund dollars, and to the extent that they are supplementing underpayment from the federal government. I want to know if we've changed our state policy towards that, and if that is crosswise with our other statewide plans.
Okay. Mr. Golden, if you can give an answer to that question briefly, and then we have Representative Quam and Representative Holberg, two more individuals who have questions for the current testifiers. Subsequent to that, we'll have Matt Anderson, Minnesota Hospital Association, David Feinwachs, and then we'll ask for testimony from the public at that point as well. Go ahead, Mr. Golden.
Mr. Chair and Representative Dean, I guess I would start with the first part of your question with regard to underpayments. I think I maybe heard Ms. Commit say something a little bit different. For both our medical assistance program and our Minnesota Care program, one of the federal requirements we have is to pay actuarially sound rates. And essentially an actuarially sound rate is one that would allow a well-managed plan to have a fair price for what we're paying them to manage the population that they're expected to have. That having been said, you have variation across plans, and in any given year, unexpected things happen. That's part of the nature of the insurance coverage. And so I think the question, as I understood it, was if in any particular year a plan has a loss, is the department required to make up that difference? We are not required to do that. With regard to the money moving between the funds, that might be a question that would be better directed to some of our fiscal staff who unfortunately aren't with us today.
Thank you, Mr. Chair. Ms. Ackby, how far does the public information burden percolate down through a multi-tiered contract structure? I'm trying to understand because that seems to be sort of the crux of this issue.
Exactly.
Mr. Chair, Representative, that's a big question. I understand that, basically the language of this law is pretty clear in that basically it relates to the government who is contracting with a private person for a governmental function, and it would apply to at least that situation. And then you have to do an analysis from there. So I think you're trying to get at how far does this go, like to the subcontracts and then to their subcontractors. And I think it really would require an analysis. But at the very least, we know that the first contract is ripe for this situation, the main with the government entity and the private person.
Thank you, Mr. Chair. And that would be one thing to look at in this legislation, not having ever been on civil law committee. It just seems as if clarification and not allowing the court to wander when there's not clarification in the statute, it'd be good to maybe touch upon that if we do an amendment.
Thank you, Mr. Holbert.
Thank you, Mr. Chair. Mr. Golden, you've had the opportunity by your testimony to review some of these subcontractor agreements, i.e. the providers' contracts with their vendors and providers' physicians. I'm probably using some of the wrong terminology here, but that's what they seem most concerned about, disclosing these subcontracts and how much they pay their individual doctors and what they pay for various products and services. Having reviewed some of those contracts, you said you see them sometimes, but they're not public under another section of law. In using your expertise, if you were asked to provide an opinion on whether or not the amount that they pay their subcontractors for these services or products, would you view that as trade secret information?
Mr. Golden.
Mr. Chair, Representative Holberg, I would prefer not to speculate on that. I think I would like to see the specific justification that would be provided on any particular data, whether in part or in whole. And I would also need to know if it mattered in the sense in our hands, some of that information is classified as non-public. But I hate to offer a hypothetical. That's something every vendor seems to ask during an RFP, and it really seems to be a case-specific and fact-specific situation.
I'll try maybe a different angle. You said occasionally you get documents stamped all over, trade secret or proprietary, but then you go through the analysis to determine what you believe is actually proprietary. Would you give the committee examples of data sets that your department has determined is trade secret under Minnesota law?
Mr. Golden.
Well, Mr. Chair, Representative Holberg, I guess I would say in determining it, the very first thing we do is we require whoever is making the claim of trade secret to justify it in relation to Chapter 13. I haven't found one recently that meets that. I don't know.
Mr. Chair and Mr. Chair, Representative, in my 2-year tenure at the department, I have not seen one where we have constituted as trade secret.
Representative Holberg.
All right, thank you.
Okay. So I have no one else on the list for these fine folks. Thank you very much for your testimony. Next on the list, I have Matt Anderson with the Minnesota Hospital Association. After that, I've got David Feinwachs, after which I will open it up to public testimony. Go ahead, please introduce yourself for the record and begin your testimony.
Good afternoon. My name is Matt Anderson. I'm with the Minnesota Hospital Association. I want to thank all three chairs for the opportunity to be here today. I don't usually do this, but to quote Kenny Rogers, I know it's late. I know you're weary. So I will be short. And no one to fold them. I will be short, and that is to say that when this hearing was called, obviously dealing with healthcare data and contracts with the state, we wanted to ensure that the committees understood that the 142 hospitals and health systems that we represent all have, at some level or another, different kinds of contracts with the state, several of which have entered into contracts referred to as healthcare delivery system demonstration projects, or more recently called integrated healthcare partnerships. And under these kind of agreements, they agree to coordinate the care for a entire population of medical assistance or Minnesota Care enrollees. And to the extent that they do that, they have similar activities and interests as some of the health plans. And to the extent that the committee was entertaining amendments or changes, we would want to make sure that they applied equally to healthcare providers as they would to health plans. The committee's discussion and the testimony today has provided a lot of, I think, clarification that the bill that's before the committee and on the floors is not intended to change current classifications of healthcare data. We were obviously, as you can imagine, concerned about patient care information, individual healthcare information. We want to continue to make sure that that is secure and private. So with that, I will stand for questions, but want to be sensitive to your time.
Thank you, Mr. Anderson. Questions from members? Representative Liebling.
Mr. Anderson, thanks for being here, and thanks for your waiting through all of this, as everybody else in the room has too. What kind of information would hospitals be concerned about? I mean, other than the patient data. We know patient data is protected. There's obviously nobody's interested in getting individual data from people revealed. But in terms of the hospital's own data, what would be kind of the core minimal thing that hospitals would think that they needed to continue to protect, irregardless of what this legislation applies to?
Mr. Anderson.
Madam Chair, I think the areas of concern for hospitals, aside from patient data, and you're right, no one's intending for that information to become non-public, information about physician compensation or other caregiver compensation. We are in a very competitive market nationally for certain types of caregivers. We have healthcare provider shortage areas in virtually every county of the state of one kind or another. Even our largest, most well-renowned systems compete vigorously with other organizations around the country, and many of these individuals can practice anywhere they want. Our weather, our mosquitoes, their challenges. If all of that information were to be non-public, it would create recruitment and retention issues.
I think you mean public.
If they were meant to public, I'm sorry, yes, thank you. If that information were all public because hospitals have contracts with the state, recruitment and retention would be one of the biggest issues that our members would have, as one example.
Thank you. Is that pretty much it then? I mean, I'm just looking for that kind of thing. Is that, I just really want to know what the core concern is for the hospitals.
Madam Chair, the concern would extend beyond that as well. As you can imagine, recruiting physicians, negotiating with vendors over supplies, medical devices, supplies that are very competitively negotiated on bulk discounts and those kinds of things. To the extent that that information would all be public, that would hurt members' negotiating power, and particularly, again, with respect to healthcare is not just a local issue. It is a national, regional competition. And so to the extent that that would put our members at a disadvantage, that would be concerning. Other types of contracts down the line, if you think far out in terms of total cost of care contracting, if providers reach out into the community to provide education about healthcare services or healthcare practices, wellness programs, those kinds of things, people that participate in those may not be considered patients because they aren't getting treatment or services, yet their participation in the program itself, particularly if it's about particularly sensitive topics, we would want to be able to keep that information non-public to be able to encourage people to participate in those kinds of sessions. These are examples, off the top of my head, but I'd be happy to try to think of others, in more time.
Thank you. And is it your contention that under the bill, under Representative Lesch's bill, that any of this changes?
Mr. Anderson.
Madam Chair, my understanding of the bill and the testimony here today, the discussion and the questions, is that the bill does not change any of the classifications of any of this information, that this information would continue to be protected in however it is classified, whether it's patient information, the physician compensation, employment information, all of that would continue to be under the existing data classifications that the Data Practices Act provides.
Thank you.
Representative Huntley.
Mr. Chair and to the witness, most of the large hospitals are in parts of systems with clinics, so what you pay your physicians would not be public information. On the other hand, most of the smaller rural hospitals are not associated directly with a clinic, and so there must be contracts that they're issuing to the various physicians that utilize their facilities. And it's my feeling that that information would be required to be released then.
Mr. Anderson.
Mr. Chair, that is one of the concerns that we have about the reaches of the Supreme Court decision, what was discussed earlier about how far down the chain does that public information reach. One of the things with when physicians who practice at the hospital but are not employees of the hospital, typically they have privileging arrangements and bill separately for their services. And so to the extent that they would be billing the state for their services, those bills done outside of the hospital system, in that case, each organization would have its own contracts with the state, and we believe that, again, that those the payment rates from the state itself, if it was a fee-for-service payment, that would be public information. If it was a payment by one of the health plans under the PMAP program, that goes right to the heart of the discussion earlier, and whether or not that would be considered trade secret or proprietary information.
Thank you.
President Mullery.
Thank you, Mr. Chair. And I guess what you felt, I used to represent University of Minnesota hospitals when I was in the University Attorney's Office, and there was huge issues with research data. We had a lot of patents. Wouldn't those be possibly public? I mean, it's a great concern to my former clients.
Mr. Chair, Representative, that
another hospital, Mayo, I think, well, I know the Fairview system, et cetera.
Mr. Chair, Representative, those issues, particularly around research development, patent issues, are extremely sensitive and very important. Most of those are governed by federal law, federal patent law, and trade secret law. The grant contracts, if there were grants between a research organization and the state, again, I think everyone here understands the contract itself would be public information, but to the extent that the organization that's doing the grant is creating data or information under the terms of the grant, that would still be governed by the Data Practices Act and subject to trade secret, other types of protections that already exist today.
Thank you, Mr. Anderson. Representative Mallory, any other questions?
No.
Okay. No other questions for Representative Pugh? Whitson, Clark, Johnson, go ahead.
Thank you, Mr. Chair. And again, this is similar to the question I had for Ms. Kismet. And it seems like there's some assumptions about the marketplace. And it seems to me that if Hospital X is purchasing a device at $100 and that Hospital Y is purchasing the same device at $150, that knowledge would be valuable in the marketplace, certainly for Hospital Y. And I'm curious why that information is, by being secret, holds prices down.
Mr. Anderson.
Mr. Chair, Representative, that's a good point, and it's difficult to explain. The best example I can have is in your scenario, if Hospital Y is outside the state and therefore doesn't have to disclose its prices, it has a competitive advantage if it knows Hospital A, Hospital B, it knows what it's getting for its supplies and can negotiate with the same supplier for a different price, and those other hospitals have no idea what it's negotiated. So the notion is, for a lot of this, becomes very, very difficult when you create differences across states for issues that are nationally competitive. And so if everyone had to disclose and it was a level playing field, then you would have an open market, particularly on the device and the supply markets and those kinds of things. But when you have, if you were to have a state where the purchases of medical devices by a particular hospital or group of hospitals is public, and their competitors can get that information without having to disclose their own information, then you have a competitive disadvantage.
Yeah, thank you, Mr. Chair. But again, I'm concerned about hospitals in Minnesota. And maybe naively, I'm thinking about a Hospital X in Minnesota and Hospital Y in Minnesota. Again, wouldn't that benefit the pricing structure if they both knew that if that price structure is open? I guess I'm getting to a larger question. We make a large assumption that an open market, where classic to a free market, is knowledge about prices. That's economics 101. And maybe I'm asking, and the suggestion is that somehow the medical industry is distinct from all other industries. And I recognize there are differences in that there's a distinct public-private partnership here. But it still seems to me that that simple question I asked, if those two hospitals are sitting in the same state, in the same community, that would be valuable information, that could drive prices down.
I don't think that's a question.
The question is, if they're in the same state, why wouldn't that serve?
Mr. Anderson.
Mr. Chair, Representative, that would serve to the extent that they serve people within the same state exclusively. The problem is that healthcare is no longer just within the state. The Mayo Clinic does not compete solely with the Olmsted Medical Center in the same community. It's competing with the Cleveland Clinic, Johns Hopkins, MD Anderson. It's a national competition, and they're buying from national suppliers. And so if one group of hospitals in Minnesota have to disclose all of their prices, but the hospitals that compete with them right across the river or across the country don't have to disclose their prices, they have a competitive advantage. And the vendors that sell to the Minnesota hospitals will not want to offer as deep of discounts because they know that everybody else will see those discounts and they'll want them too. And so they'll say, you know what, your hospital, your prices are going to be put up on a billboard for everybody else I sell to see. And so I'm going to make sure that anybody else I sell to, I'm going to sell to for that price or less, because I'm never going to be able to sell it for more. And so they're going to put Minnesota's prices at the top, and they're going to negotiate lower for anybody else who can negotiate lower. The second point I would make is that in this respect, healthcare, in fact, is not different than other businesses. If you go to your, there was a suggestion earlier of the local car repair shop. and say, oh, you know what, we want to know how much you pay for your tire supplies. The local repair shop is going to say, what I pay, my supplier is my business, and I negotiate those rates myself. If I have to tell everybody, then I'm not going to be able to negotiate as good a rates. Businesses have their own agreements, their own competitive negotiations, where they negotiate their own prices that their competitors don't know about. That is the free market. That is how it works. I'm able to negotiate the best rate I can. I think it's a good rate, I enter the contract. If I don't think it's a good rate, I find a different supplier. But what that rate is and how I pay for it to create my services or my products, my competitors don't know.
Representative Pugh.
Thank you, Mr. Chair and Mr. Anderson. My question and my comments and question are very much along the lines of the conversation that we just heard with Representative Johnson here. What I heard you say, Mr. Anderson, was that the healthcare providers would be very concerned, wanting to ensure that they were protecting, for example, compensation of physicians. And so my question is really to one of our chairs of the committee, wondering how the response that we heard with regard to protecting compensation squares with the Women's Economic Security Act that we just passed off the floor a couple of weeks ago, and just pay equity specifically. And I'm just wondering, any thoughts about that?
Well, I don't know if I'm not sure maybe if I understand your question about, maybe can you be more blunt? I'm sure there's a blunt question in there, but it's late and I wasn't getting it. So just go ahead and be blunt.
Well,
I'm not sensitive.
Thank you, Mr. Chair. I put that out there as straightforwardly as I could. I mean, I'm just sitting here listening to this and hearing that something that healthcare providers would very much want to protect. And it was, I think, the only example that we heard was compensation of the doctors, for example. And it just seems to me that, in the interest of openness, this is exactly what we talked about with regard to the Women's Economic Security Act. And I'm just wondering how, it sounds like maybe Representative Liebling might be able to shed some light on this. But this just seems to me to be the exact same scenario. And I'm concerned about that.
Well, Representative Pugh, actually the parallel kind of occurred to me also, that we're talking about people knowing what other people are compensated at. But I think that the difference here is that in the Women's Economic Security Act, the purpose of not being able to penalize an employee for discussing compensation with others is that sometimes employees find out that they are being discriminated against and they wouldn't otherwise know it if they're unable to discuss with others what they're being paid. And that, in fact, is what happened to Lilly Ledbetter, whose case was the very first one that, that was the basis for the Lilly Ledbetter law that was signed into law by President Obama when he first took office, that she, for many years, didn't know that other people doing the same job or less were being paid more. So I think it's a little bit different, although obviously there is a parallel. And I think that the hospitals and others are saying that if providers can compare their compensation, that they might demand more pay, and in fact that could happen to women who are being paid less and find out that others are being paid more.
And Representative Pugh, I mean, now I know which provision of the act you're talking about too, with respect to the pay equity, and I was thinking of that parallel as well too, with respect to why we have open access to government records, because if the taxpayers find out that they're not getting a square deal based upon the contracts that are being let by government, they have a right to challenge that, either in a committee room like this or under their freedom to assemble. So someone like Lilly Ledbetter, who was not getting a fair deal because of the secrecy provisions, there had to be affirmative proof on the part of employers to say, well, hang on a second, why do we have the right to discriminate? So That's how I saw the parallel. I'm relatively sure that's not the parallel you're talking about, but maybe if you feel free to clarify more.
Well, thank you, Mr. Chair, and I won't. It is getting late, but I would just make the point that, you know, from a competitive advantage standpoint, you know, there are a lot of things that do go into compensation, and I would imagine that depending upon what happens, you know, with this legislation, that you know, hospitals will need to comply with whatever legislation is passed, just like businesses. And I think there are some parallels here, and I just really wanted to make a point, and thank you.
Thank you, Representative Pugh. Representative Holberg? Okay, so that's Huntley.
Mr. Chair, I just wanted to respond to Representative Johnson, and I would agree that Mankato does not directly compete with Iowa hospitals. However, they compete for the physicians that they need to hire. They compete for the nurses they need to hire with them. And I will say that if you we're in Duluth, Duluth has 2 hospitals within Duluth, and 5 miles away in Superior, Wisconsin is another hospital. If you're in Stillwater, Representative Dean, you've got to compete with the hospital in Hudson, Wisconsin, which is maybe 10 miles away. If you're in Hastings, you have to compete with the hospital that's across the river in Wisconsin. If you're in Moorhead, you have to compete with the hospital in a much bigger city right across the river. And do we want to put our hospitals at a disadvantage for the competition they need to compete with these ones just across the river?
Representative Clark Johnson.
Mr. Chair, thank you. Just quickly, my point in raising these questions today is because I come as a citizen. I've only been in the legislature for a year and a half, and I've been paying my health care, and I've been watching it for years. And I'm genuinely questioning the pricing mechanisms in health care. I think everybody in America is doing that. And specifically to Representative Huntley, I work at Minnesota State University. My salary is public. All of my colleagues' salaries are public. We compete for professors who are highly specialized, especially in some areas, nationally and internationally, and we seem to do fine. So there are other systems. We know that there are systems created, whether it be at Minnesota State University or in Norway, with respect to healthcare or whatever. We know there are other ways of looking at this. And I'm just kind of challenging the assumptions that I heard here today, that we've got to keep it secret, that by keeping it secret somehow in the healthcare industry, that creates lower prices. That may be true, but I'm not buying it completely. And I think it's incumbent upon us as a state. It's not going to happen today. I understand that, but I grabbed my moment today, and I'm sorry for taking a little bit of time with this. But this is an important issue, because when there are other models that are somewhat similar, we need to learn from those and we need to attack it. I guess that's next year, and if I'm forced to get reelected, maybe we can get on to that. But I thought that when a lot of the assumptions we're hearing, a lot of the testimony tonight, isn't that horrible? A lot of the testimony today is based on some pricing assumptions, and so I thought it was incumbent upon to at least challenge those assumptions, to realize that there's more than one paradigm on that, and another day let's take a look at it. Thank you very much.
Thank you for your testimony, Mr. Anderson. David Feinwachs, please introduce yourself for the record. Begin your testimony. After that, members, we will take public testimony. Can I just see, by a show of hands, how many members of the public here would like to be heard on this? I see 1. I see 2. I see 2. I just said 2. Okay, thank you. Go ahead, Mr. Feinwachs.
Mr. Chairman, members, my name is David Feinwachs. I am a resident of St. Paul. I represent no particular group. I have an interest in these issues and have some knowledge base in healthcare, having worked in the area for some number of years. Let me first of all say that the bill you are considering is a very good bill. The Supreme Court made a mistake. The bill would rectify that. Let me also say there is no reason to exempt health plan data from this bill. In fact, quite the contrary, it would be a really bad idea. Now, let me tell you why. In the past 13 months, Minnesota has been the recipient of 3 reports: the Siegel report, the PCG report on the value of managed care, and most recently a study of capital reserve limits in Minnesota prepared for the Minnesota Department of Health dated March 14, 2014, which I'm sure most of you have not had a chance to digest yet. These reports indicate that there are some serious problems in our system. Our state, our Department of Human Services, and our plans are currently under investigation by the federal government. That investigation was instituted at the end of 2012. The purpose of that investigation is to determine whether or not we've been cross-subsidizing programs with federal money, which is in fact unlawful. That investigation is ongoing. Let me suggest to you a possible reason for concern about disclosure under the Data Practices Act. The most recent report that I referred to, the March 2014 report prepared by the DeWeese Company, says this: interdependencies and formal business relationships through service agreements and risk contracts between HMOs and affiliated insurance companies and provider organizations currently provide legal mechanisms to financially subsidize lines of businesses. Now, those things may be legal under NAIC guidelines, but it is completely unclear whether they are legal under federal law. And to have access to those agreements which appear to provide cross-subsidization would seem to be vitally important. And making such agreements illegal would be a really bad idea. Furthermore, as I sat here this afternoon, I listened to testimony that said that DHS, which the Siegel report said had no paid claims data for the period of their review from 2003 to 2011, that I heard Dr. Golden say that there was no statutory authority. What Siegel said in their report, and I want to read it because I don't want to misquote it to you, Siegel briefly reviewed the managed care organization contract, and we believe DHS had the authority and should have collected data over the period being reviewed. We were told DHS did not push for this data, and it was met with significant resistance from the MCOs. That's page 16 of the Siegel report. We didn't need statutory authority to collect the data. We had contractual authority. DHS chose not to have it. And the reason they chose not to have it would be fascinating to explore. We are then left with the issue that there may be a larger scheme here, and the public is entitled to know where the money went. More importantly, I would like to remind you of this. We've used managed care in this state for almost 3 decades. You know what budget certainty we've achieved? We're certain that every year our costs go up. You've heard from a myriad of providers that they're paid nothing. Where did the money go? We represent to the federal government that our cost of health care is astronomical, yet nobody seems to be paid any of the money. Insurance reserves are enormous, and interestingly enough, the DeWeese report says that our programs appear to be actuarially based, cost-plus historical programs. This would fly in the face of the assertion that there's any insurance risk here. Even Governor Dayton himself, in July of 2012 in a public radio interview, said that these are cost-plus programs. And Siegel indicates that they are cost-plus programs. Providing additional secrecy and protection for either the plans or their large health system providers who apparently are engaged in achieving this cross-subsidization until we examine it, until it is determined whether it's lawful, would be a horrible public policy idea, and I urge you to reject it. Thank you.
Well then, any questions for Mr. Feinwalk? Representative Grunhagen.
At this hour, I'll just make a quick statement. I appreciate, and I've talked to you for the last few, this subject's like quicksand. The more you get in it, the further down you go. But just one response. It's one of the things I looked into. First couple of years I was looking into this, and what the plan showed, and I think the department confirmed at that time, I don't have the notes with me, is that the enrollment has gone up in these plans at a faster rate than the funding has increased. I had a graph on that to show that, but that's one of the reasons some of this, and I'm not saying there aren't some problems, but the enrollment has gone up faster than what the funding has increased. But we're talking about billions of dollars, so I'm sure there's room for further examination. Thank you, Mr.
I'll make a comment as well, Mr. Feinwalk. I mean, this healthcare is not my area, nor do I intend it to be my area. That said, I do have some
tangential knowledge of cost-plus contracts, and if in fact that assertion is true. My only familiarity with cost-plus contracts is it applies in areas whereby they can't be available through other means, which is not the case, as I understand, in healthcare. So, I don't know. I'd probably like to learn more, but I'm making probably a very bad statement on my part to even let people know that. So the first request I have had for a testifier was Mr. Rick Heller. See here. Mr. Heller?
Thank you, Chair.
Are you both associated? Are you testifying on behalf of each other, the same group? Okay. Well, Ms. Lee, then, if you could come up next. Thank you. Mr. Heller, go ahead. Introduce yourself.
Thank you, Chair. I'm speaking on House File 2167 on the 23rd of April. First of all, I unofficially represent the twice exceptional and prick disabled. I have a hard time accessing some of these documents because they're not provided in a timely manner for the public, especially when I learn by oral language and I use a reader to read out loud. However, if I understand this topic appropriately, there was a similar bill in the Minister of Education which talked about access with contract language, I believe, with contractors. This kind of somehow parallels that. And I got a response back from the Minister of Education saying basically the question I had arose was, will that content be made accessible according to Statute 16E? As we all know, iPad is exempt from that. Again, I see a big disconnect from informational requests and data that's fully accessible. And frankly, it's silent on that. So we can all talk about the content that's in front of us and what's considered trade secret. However, it's no secret that the capital is exempt from Statute 16 based on my testimony this year, including all other agencies that are administrative. So frankly, maybe slightly off topic, however, if we can't get the content accessible in an appropriate manner, frankly, I don't know what the difference is going to make regarding the trade the trade secrets. And I do believe the chair, his area of expertise is rules, and currently the House and Senate rules are silent on accessibility too. So hopefully in the future we'll take a serious look at this information as we continue to look at not just the content if it's a trade secret, but the content can be fully accessible, for instance, with Adobe Reader. Thank you for this opportunity to speak.
Thank you for your testimony, Mr. Heller. Ms. Lee, please introduce yourself to the record and begin your testimony. And please, if you could specify at the outset whether you support or oppose House File 2167 as written.
Yes, Mr. Chair, members of the committee, thank you. I'm Jean Lee, President and Executive Director of Children's Hope International, which is legal advocacy in policy in our family centers, which are shelters, especially domestic abuse shelters, transitional and permanent housing, and APAC, which is a consortium of service providers providing holistic services and other trusted professionals. As far as the House File 2167, we just felt it didn't go far enough because what we identified in the handout you have is that there are third-party vendors who have found ways around existing law, and they can even get around the proposed law. What they have done is they have made grantees fill out personal client data on the forms with their logo, even though they are a third party acting as if they were a state agency and acting for a state agency at other times. And in this way, a grantee's client then becomes their client, and they can go and access funds and use the client data for all types of different purposes, which also includes being able to market to others, for example, to realtors and lenders. I'm a certified housing counselor, so I do know the type of data that can be collected. And we can collect data which is more extensive and more in-depth, confidential personal data on a person than doctors can collect on an individual, than attorneys normally collect on an individual. And they don't have the privilege, client privileges, regulations that attorneys and doctors have. Clients are also asked to sign waivers so that this information could be shared and they can bypass some of your laws. So I see these as being loopholes as to how they can get around things. And we had introduced under Representative Allen a bill that we thought would close some of the loopholes. But we were told that existing law takes care of it, and now as you found out through the Supreme Court, there's an interpretation that existing law doesn't necessarily protect it until you specify in a contract what's allowable and what's not allowable. So we feel that the contract should be further detailed as far as what's allowable, what's not allowable. And I provided other information regarding other roles a third-party vendor could access the information. And because of it relates to another bill that the Civil Law Committee earlier heard, and at that time, I didn't want to burden you all with tons of backup documents. So I've just cited some of the information as far as supportive evidence that can support the issues as far as problems that are occurring. And I hope that you will close some of these loopholes. Thank you.
Thank you for your testimony, Ms. Lee. Please introduce yourself to the record. Begin your testimony.
Thank you, Mr. Chairman. Matt Ealing, Minnesota Coalition on Government Information. I apologize I couldn't be here earlier in the hearing. We've been here a long time. I'll be very brief. We support 2167 as it is. We would like to see this go forward without amendments. We think the question posed to the legislature is very clear. Should Chapter 13 apply to private entities that are contracting to perform government functions? We think it absolutely should. We think the clarity that the bill adds is right on. These private entities are performing government functions that the taxpayers of Minnesota pay for, and the taxpayers should be able to see what they're doing. A lot of the other issues that were raised today by the health plans and others, these are separate questions for another time, we feel. These are separate data points. Chapter 13 has a lot of provisions about should specific pieces of data be not public, and those questions can be dealt with separate from the general proposition that's at stake in 2167. So we would like to see this go forward as it is. It's a very straight-ahead proposition, and I'm happy to take any questions.
Thank you for your testimony. Any other questions from members? Seeing none, thank you.
Thank you.
Discussion by members of the committee. Representative Huntley.
I have to leave, so I'm going to be brief, but I support most of what's in 2167. I do think that we need to be very aware of the possible impacts on the healthcare industry. And we may need some changes in there, but for most of 2167, I think it's the right thing to do. But we're sitting here with maybe 2 or 3 weeks left, and we're talking about an industry that is 17% of the national GDP. And so I assume in Minnesota it's probably 15% of Minnesota's domestic product, and it's 33% of the state budget. Healthcare, human services, 33% of the state budget. We've learned for most of what we do here will have also an impact on the non-government programs involving healthcare. And so what we do, if we're just looking at government healthcare programs, we're going to greatly affect the non-government healthcare programs. So I would suggest that we think very carefully about what we're doing, and I think we're going to have to do some kind of an amendment to protect the health system for a period of time, perhaps 1 year. and then you'd have all next year to really evaluate this problem in the healthcare system, which we have not had the time to do this year. Thank you, Mr. Chair.
Thank you, Representative Huntley. Representative Gruenhagen.
Real quick, I agree with most of what Representative Huntley would say, and the only thing, if those costs in the public program go up, your 2 pills of Tylenol for your wife will go down about $5. So there's the teeter-totter effect.
Well, at least a nickel.
Yeah, right.
Other discussion from members? I guess what I'm interested in hearing from members is, what do you think I should do with my bill? I mean, normally I don't care what people think, as you all know, but I am interested. Representative Gruenhagen?
Mr. Chair, if you don't do anything, doesn't the Supreme Court decision apply?
Well, if we don't do anything with respect to the bill, or if we do something, if we pass the bill or we don't pass the bill, the problem remains the same, I think you heard from the health plans.
Yep.
There's no change. So it really doesn't matter whether their idea goes on this bill or some other bill. They, in their opinion, now desperately need a change in light of what the Supreme Court decision has revealed to them. So in reality, the only reason we're talking about House File 2167 is that's the bill that made them realize, whoa, hang on a second. And a lot of lawyers have gotten paid a lot of money over the course of the last month to decide what they're going to do about it. So, Representative Legland.
Well, when I had a discussion with Ms. Kmet earlier, can't remember now if it was today or yesterday, but anyway, about this whole thing, I told her that I feel that the burden is really on those who want an exemption to come in and tell us what very, very narrow exemption they need and exactly why. And frankly, what I heard today, I did not think met that burden. And especially some of Representative Johnson's questions, I think were right on. Those of you who don't serve on Health and Human Services got a little taste of what some of the issues are here. And they're huge. And for many years, as I let her know, I mean, the plans know I feel this way, they've been telling us for years that they can't give us the data because it's proprietary. That we who have to make decisions about how to fund them, and say we raise a rate for a provider, we have no way of even knowing if that rate got passed through to the providers in most cases, other than fee-for-service, where the state is doing it. So there is a serious problem here already, and they've been telling us for years that they had protection, which now they're claiming they don't have. So I don't feel they've met their burden, and at this moment, I don't know what language they have that they referred to, that Ms. Kmet referred to, but I don't feel inclined to put any special protection forward for the industry at this time, which isn't to say that they couldn't perhaps do a better job and come forward with something. But I think that at the very least, we as policymakers have to be able to know what they're paying, at least on a more granular level than we know it now. We just have to, because what Mr. Feinwalk said is true. I mean, I didn't have the reports in front of me, and Representative Lane was referring to the same thing. We know that the state has really been taken for a ride for a very long time, and I do believe it's been tightened up considerably by Commissioner Jessen and her group. However, that doesn't mean that it's been done as well as it can be done, and that we yet know, we as policymakers, exactly where we're spending the public's money. And it's a ton of money. So, I mean, this is our obligation, and I am not willing to give them some kind of blanket exemption that's going to further give them ammunition to say that we can't know what they're doing with our money. So that's where I'm at.
Representative Albright.
Sure. I think one of the concerns I have is that any decision by this body or by the author of the bill to take it forward, and if it were to pass into law, and I think it might create a court challenge because it seems to run in the face of contract law from the standpoint of proprietary information to mutually agreed to terms. So I would suggest, as Representative Huntley said, that we pursue proceed with great caution at our own peril.
Representative Laughlin.
Thank you, Mr. Chair. And well, we spent a lot of time talking about health care because for some of us that's really important. And we have heard repeatedly the frustrations with the growth in the Health and Human Services budget. We who serve on it are frustrated at the thousands of people who serve on and wait for years and years and years with no hope of getting off of waiting lists because all of our growth is in the health care component. And we have people who've been waiting for sliding fee child care for almost 3 years now. You should almost sign up years before you're pregnant and see if you can get on the list with a fake child. I mean, it's ridiculous how our programs aren't working. We would not tolerate a young person who of promise being told you can't go to the university until you get off the waiting list, and we can't tell you or your family any idea if it's 3 or 5 or 10 years that you'll get off the waiting list. And so that's the context in which we feel such pressure to understand what is happening in healthcare. At the same time, though, if I step back from that hat, this is about a Supreme Court ruling that affects all governmental entities and all contracts. And the Supreme Court has made a choice that says, if you want this to apply, we had always thought was the law, you have to put it explicitly in contracts. And I think it is our duty and our responsibility to put that into the state law so that all governmental units and all governmental agencies know that is the expectation that has been the longstanding law for most, if not all, contracts. There are questions about interpretations on the health plan contracts that the Health Committee and others will have to sort through. But I definitely think this law should move forward. I agree with Chair Liebling that at this point we don't have enough of a clear picture of what the problem is for me to feel comfortable with the direction on the health industry issues. But for sure, I think the underlying bill here, as it applies to everything else in government, should be clear and reinforce what has been the standard of the state.
Representative Holbert.
Thank you, Mr. Chair. And I think the bill is important to be passed as is, and I don't like to view these issues specific to one particular industry or organization. I think that we have protections on the book for trade secrets. I have asked for specific data sets that they want protected and what the reasoning for that is. If it affects their business, it may in fact similarly affect other businesses and other sectors that interact with government. I think we should keep talking to see if we can get some specific data sets for specific reasons. But I do think that, Mr. Chair, your bill is important to pass because I believe that it's been the law since 1999 that they were supposed to adhere to this standard. I'm concerned when I hear some of the comments coming out of the Department of Health and the slicing and dicing that's apparently been going on with what parts of Chapter 13 apply or not with their contracts. That concerns me. The fastest way to address that issue is to pass your bill and then keep talking on the other issues.
Representative Quam.
Thank you. It sort of seems like we've been called on an accident scene, and we're sort of on the triage stage. We're assessing the scene. We're just starting to take vitals, and there's no way we have sufficient information to do any diagnostic work. I concur with the general assessment that we have to do something to cover the entire situation and issue. But specialization, I think we really have to look at the specifics, the subsets, and then delve into, if it does percolate through, some of the data sets may stop at the first level, some may stop at the second, maybe financials go the entire route. And that's the type of activity that's going to require a couple years. So I would concur with Representative Holberg and hope that other members sitting here would join in trying to solve the more in-depth issue that we've been confronted with.
Any other comments from members? So I would say this. Those of us who deal with Chapter 13
understand and know that the starting point of all of this is that data is presumptively public. It assumes that all government data, you shine the sunshine in so that the public and the taxpayers know how their money's being used. That's the starting point. That's the presumption. And I heard testimony today from an attorney for the health plans who said, well, that certainly wasn't the intent of Chapter 13 at all, to include these provisions of these contracts. And I was surprised to hear that. That said, I am open to hearing more specifics, but essentially it's up on the floor on the calendar for Tuesday. So if there's going to be a specific outline of the data sets as described by Representative Holberg, I don't know the possibility of getting all that done between now and Monday at noon. But if I was getting paid $300 an hour, I bet I could find a way to do it. So maybe there are some good lawyers out there who are skilled enough to develop an amendment that is necessary, that is greatly prescriptive about the data sets that are going to be considered, and restrictive about a timeline, in which case I'll take a look at that before Monday at noon. But seeing no other discussion, the committee is adjourned.